May it please, Your Lordship.
Yeah.
As regard item 12, my Lord,
Yes.
item 12, my Lord, we have filed a affidavit in reply. But I may be permitted to bring on record. Your Lordship has fixed it at 2 o'clock, my Lord. If you please.
May please, Your Lordship. So I paid for listing motion matter.
Yes.
Tomorrow, Your Lordship. Yes, urgency matter.
Just 1 minute.
Four.
Yes.
Paid for listing in motion matter, bench relating to bench 4. Tomorrow, Your Lordship, there is urgency.
What is the urgency?
Urgency market settle with the lowest bidder, violating the terms condition of the tender as well as law. Yes, yesterday I filed. Yesterday I have filed.
জনগণ তলত নমাই দিওঁ। তলত নমাই দেখা পাম ৰ'ব নমাই। Yes. You want the unlisted motion.
Unlisted or day after? Tomorrow, Your Lordship.
Tomorrow.
Tomorrow.
May I please, Your Lordship? I beg to mention for listing of admission matter, maybe Monday, my Lord.
Why?
My Lord, it's related to custom, Your Lordship. A part payment was done. There is a direction from this honorable court, and my Lord. Despite of that, a part payment was done, leaving an outstanding amount. Now this is the 5th round of litigation, Your Lordship.
Okay. Wednesday.
My-
Wednesday.
Hi there.
For the Yes,
In item number 2324.
argue,
No, my Mr. Bhatra is on lake.
it can't be on legs because of the fact that on the last occasion, he promised the matter. That is why,
I've
in
informed.
spite of dismissing the petition, the appeal on the last occasion, we're supposed to be there, else take the blame of, wanted the year of 1 lakh. I was about to impose the cost of 1 lakh
I'm
for
extremely
your
sorry.
appearance.
I was stuck up in the traffic jam and well,
Can't help it. You know the matter is there. Argue now.
my lord. My lord, these two matters are, my lord, filed by the mother of the injured. There were 4 occupants traveling in a Maruti car, my lord. The car was driven by the son. Father and mother were in the car, and a minor child was also there. My lord, while they had reached a destination, my lord, during the accident occurred at around 10:30 or 11:30 or so. There was my lord, the plea of the claimant is that there was a mechanical defect in the car. Because of that reason, my lord, he could not control the vehicle and the accident had occurred. My lord, the
Case, how would this case come before the Motor Accidents Tribunal?
that's
It would
Exactly,
be a case
madam.
of consumer or a personal liability which is there.
yes, my lord, they could have come to the insurance company directly, and whatever the PA coverage was there, we could have settled that.
It is only limited to the.
Yes. Yes, my lord.
what do
Only
they-
only with regard to the item where, my lord, an amount of 50,000 has been awarded, that, my lord, can consider because she was an occupant of the vehicle. In this case, the other case, the son was driving the vehicle and he had, my lord, committed the accident. My lord, he
It's
had,
not about mechanical failure.
yes, my lord, that too also
So
was
maybe
not
if
proved.
it is a mechanical failure, that insurance company can be there, but this is not on account of when third party involved.
Yes, my lord, exactly, lordship.
There is
And
no
all this
Motor
decisions are
Accidents
there.
Claims Tribunal could not have entertained the jurisdiction.
My lord, correct.
There's a judgment on that.
My lord, I'll just give the citations, my lord. The latest one is Ram Khilari, my lord, and there are few Juma Saha, my lord. I'll just give the citations.
Who is they paying for the respondent?
Mr. Sahewala is here.
Where is he? Why is the matter pending since 2004 for this
My
simple?
lord, in the meantime, the respondent informed that the respondent claimant had expired. So we had to substitute them. The legal heirs are on record. And the claim has been filed against the father, my lord. The husband of the claimant.
What happened to the larger bench judgment?
Yes, my lord, I have gone through that. That is, it has been, my lord, referred to a larger bench to decide whether in such a cases, my lord, under section 163A only, man. Whether the occupants will be, whether the families of vehicle owners who die in self-accident can be allowed compensation against no fault. This has been referred to the larger bench, my lord. But that was with regard to
No,
163A.
that is 163.
163A, not
That is
166.
limited to 5 lakhs or 2
My lord,
lakhs.
my
whatever
lord,
may be.
my lord,
They're not
my
on
lord.
that.
Look, I have given a list of citations which I am relying on, my lord. Jumasa is absolutely clear on this.
There is a complete stay.
My lord.
There is a stay.
Yes, my lord. We did not deposit any amount, my lord. In fact, my lord, this matter was filed long back when I was in the chamber. Very recently, it has been marked to me. So whether any amount has been paid or not, I am not very sure about it, my lord.
Motor vehicle check करता हूँ. And the other one is other claim proceedings is there are two
Yes,
proceedings.
it was an analogous case, my lord. In the same accident, the minors.
Now, who
son
has filed the other claim?
Same mother, my lord, mother
One is by the mother for the son,
for the son. Second one is also by the mother for the son.
for herself.
For herself injuries, yes, my lord. For injuries herself, 50,000 and odd has been awarded. 50,000 and odd has been awarded. That, my lord, can consider, my lord, because since occupants of vehicle, they will be covered. It was a comprehensive policy, my lord. There were some injuries on the hip fractures, left hand fractures and all like that.
Why they are referring to 163A? Where is 163A?
In the claim, my lord,
Oh, in the, I don't find it in the motor vehicle check.
163A, my lord, is in the older act, my lord. Now it has been taken away, my lord. Amended, my lord, after 2019.
Where can I get the content of section 163A?
In the old act, my lord.
Understood, but where do I get it? Is it quoted anywhere in the judgment?
Yes. In income, it has
Huh?
paragraph 22, my lord.
In
2009 13 SCC
paragraph?
22. 2009 13 SCC 710, my lord.
Paragraph 20
22.
in the Nigama.
Ningamba, yes, my lord.
Where is it? I want to see the content of the section 163A. Here it says that we can get it in this judgment of Oriental Insurance.
Rajni
You have
Devi.
given 2008 5 SSC 736.
My lord. Yes, my
Ah,
lord, paragraph
yeah, yeah,
8. Paragraph
In this
8, my lord.
case, I think we will get
Paragraph
Okay.
8 it is quoted, my lord.
what is the second schedule?
My lord,
Where do I get the second schedule?
in the MP Act itself.
You have the old book.
Yes, my lord. My lord,
Mr. Batra, I dismissed the matter on last occasion on the ground of you have not appealed. At the, at your request, I revived it.
my lord, I am
And
obliged.
then
my lord.
also you are not prepared and got the books. Not prepared. But I can't let this matter pass away.
Well,
He said that you have not been able to satisfy this court, we dismiss it. That is the only way out.
uh, I leave it to the wisdom of this one.
What?
I leave it to your lordship, my lord.
Can't help it. I'll say that yes, he has not produced it, so therefore. Hey, আগৰ এখন কিতাপ দিয়কচোন. We have incompetent lawyers. The book. Earlier Motor Vehicles Act prior to 2000. This is an amendment made in 1994.
It's there prior to 2019 also, my lord, that book also. Prior to 2019 or above.
এখন please. পুৰণা এখন দিয়কচোন. এখন চাওঁ. কেতিয়া? সৰু লেখা আছে ন কেতিয়া? হা? পুৰণা এখন আছে. After the 1994 amendment.
खड़ी तो हो. सुनो तो सुनो कम से कम.
Yes, madam, argue.
My senior is on his
You
way.
are in a better position to argue, taking into account the counsel appearing on behalf of the, yeah. Not ready. Two thousand 18 or ago. 2019 or amend हुआ sorry नहीं किया उसको. Argue. Where is your senior?
Lordship is in his way. He's on his way, Lordship.
Yes, Mr. Sayawala.
My lord, the second schedule is available. Yes.
You don't have a case.
Dada.
My lord, actually, my lord, this matter is still to be decided.
Huh?
Yet to be decided by the Supreme Court. That is referred to full bench.
Maybe whatever it is referred. You don't have a case because the reference is only limited to the extent of 163A at best.
Yes.
But how at best you can file an application filing for giving you this amount?
My lord, judgment, your losses major. 26 दे दिया.
यही वाला है ना?
26 3
हाँ.
हाँ?
एक मिनट.
हाँ हाँ. Yeah, first case one. ये नहीं है क्या पुलिस? पुलिस? Any person, including the insured. Yeah, there is no.
It will.
What is this, Mr. Batra?
My lord.
You have given.
No,
What is this?
so this is insurance policy, my lord.
Oh,
Certificate of insurance.
now here is a case where the son was driving
My lord, yes.
along with the family. The insured was also one of the members of the accident who suffered. Now, on account of a mechanical failure, the accident happened. Now, the tribunal assessed the compensation as a third party proceedings. It could at best have been a case under 163A,
Yes.
at best, under 163A.
163, yeah.
But then also there are many judgments to the effect wherein it says that no. Just for example, in that case of Oriental Insurance versus Rajni Devi,
Sir, 2008. Huh? Yeah. 2018.
is on the owner of the vehicle as a person cannot be both. Claimant as also a recipient. The heirs of the so-and-so could not have maintained the claim in terms of so-and-so of the act. For the said purpose, only the terms of the contract could be taken recourse to. Accordingly, to the terms of the contract of insurance, the liability of the insurance was confined to rupees 1 lakh. This is Oriental Insurance. Now, the judgment by which it has been referred is the judgment by which was given by, in the case of Wakia Afrin.
Yes.
Now let us see what it is mentioned out there. Kindly see paragraph 15 onwards.
Yes.
Read it.
My lord. We
Whoever
have
has a better-
observed that cases referred to above with respect to the claims raised by the legal representative of the deceased or the injured owner, who was either driver of the vehicle involved in the accident or its passenger. While Dhanraj so-and-so, Juma so-and-so, so-and-so dealt with the claim petitions under section 66, 166 of the Act. Rajni Devi and so-and-so dealt with the claims under section 163A. In Salam, while the court rejected the application filed under section 166 and the learned judge also made an observation that section 163A was not invoked. Insofar as is concerned, while the claim under section 163 was found to be not maintainable, there was a direction to the tribunal to examine whether the claim could have been sustained under section 166. There is considerable variance in the observation made in the decisions, but however, as a principle, statutory liability was held to be not applicable in case of owner insured. Since the coverage was confined to third-party risks and those specified in section 147, read with 149, we cannot but notice that 163 is a special provision in which a non-obstancy clause which overrides not only the entire provisions of Motor Vehicles Act 1988 but also any other law for the time being in force and any instrument having the force of law. We cannot but understand the non-obstancy clause having a superseding effect over the laws of insurance or even the terms of policy, which definitely is an instrument having the force of law. It is also to be noticed that section 163A makes liable the owner of the vehicle or the authorized insurer to pay in accordance with the second schedule in case of death or permanent disablement due to accident arising out of the use of the motor vehicle. Right? The principle that the liability with respect to an accident is on the tortfeasor, and in case of a motor vehicle accident, if the tortfeasor is the owner has the vicarious liability, which liability is invented by the insurer when there is a valid policy. The liability is essentially of the owner, but provision in addition to the insured owner makes liable the authorized insurer too. Hence, when there is a valid policy issued in the name of the vehicle involved in the accident, a claim under section 163A, as per the words employed in the provision, according to us, covers every claim
and is not restricted to a third party claim without any requirement of establishing the negligence if the death or permanent disability is caused by the reason of motor accident. This would also take is in the liability with respect to the dealt with an owner or a driver who stepped into the shoes of the owner. If the claim is made under section 163A, divorce statutory liability under section 147 or the contractual liability as reduced to writing is an insurance policy. It would override the provisions of section 147 and 149 along with the other provisions of MB Act and the laws regulating insurance as also terms the policy confining the claim with respect to an owner driver to a fixed sum is according to us is the intention of incorporating the non-ostensive clause under section 163E, providing for no fault liability of claims, the compensation for which is restricted to a structural formula under the second schedule. It is beneficial piece of legislation brought in keeping in mind the enhanced chances of accident resulting from the prevalence of vehicles in overcrowded roads of the society today. It was social security scheme brought about by considering the need for a more comprehensive scheme of no fault liability for reason of ever increasing instances of motor vehicle accidents and the difficulty in proving the rash and negligent driving. We are of the opinion that this issue of concerning the liability of the insurer in a claim under section 163A, the owner insured requires an authoritative pronouncement. This dictum arising from the various decisions of different benches of the two judges is that the claim under section 163 is restricted to a third party risk, which with all the respect of our command, we are unable to agree with it, my lord. We are conscious that the provision of section
So if
163
this judgment has no value, then
my lord,
this judgment has no value.
no, we have to wait, my lord, because
No,
My
we
lord.
don't wait. You see, the law is very clear. There is a Supreme Court,
Because-
another constitution bench judgment to the effect
Ah.
that merely referring it does not wipe out the law which has been laid down. So therefore, the law which has been laid down is those judgments wherein it says that the person who is the driver also, who is the driver or himself, unless it is personally not there, he would not get it. Let us see the judgment in the case of the three. Let us therefore look into three judges. These are the two judges. Let us see the two. How can if you see the judgment, I think it's a 2001 5 SCC. There's a constitution bench judgment wherein the Supreme Court itself had deprecated to the fact that if two judges cannot question a three judges judgment, there's no quarrel with that proposition. So therefore, we are bound by the constitution bench judgment on that. Be that as it may, if you want, I can give you the reference of that judgment. But anyways, let us now look into the three judges judgment, how it is holding. I think Nigamma is the three judges judgment. Two judges. Sinha is two judges. Any three judges?
no, my lord.
Let us see the judgment. A judgment to look.
All are two judges.
No, we look into this judgment. Punita Rathi. 1998, 1 SCC 365. 1977, 2 SCC 441. Give me two days, two judgments. 441. And the entire proceedings was wrongly taken up. Anyway, let us see from the angle of the second schedule how much a person will get.
Motor vehicle account.
As per here, the claimant has made claim for rupees so and so towards expenditure that is not there. As regards his fixed income, Non-becoming. Apart from that, rupees has been fixed for future. Now, rupees 5 lakhs. Need a claim of rupees 15 lakh, 3,000 for loss of earning. So it is 21,600.
Well, 2020 judgment also, my lord, your lordship.
21,600. So it will come to around that 480. Yes, Mr. Batra, how do you calculate as per the second schedule?
My lord, this is a case of injury, my lord,
Okay.
not a
Injury,
death
how
case.
much?
my lord.
Permanent injury, my lord.
Injury is, you divide it by 1/3.
Permanent.
It will be reduced by 1/3 in
Permanent
contribution
disability.
expenses which the victims could have incurred towards maintaining himself. This is for fatal accident.
Fatal accident.
Yeah, in pain and suffering, 5,000. So injury, how much?
Whatever are the medical expenses, plus some, my lord, under different heads, my lord, are to be given only.
Different heads means
My lord,
the other heads.
my lord, the other head.
General injury, pain and suffering 5,000, non-previous injury 1,000, medical expenses, actual expense incurred supported by bills 15,000, but not exceeding as one-time payment of 15,000. Let us see the proof of negligence essential to sub.
Okay.
File
The owner of the motor vehicle or the authorized insurer shall be liable. Now, the authorized insurer will only come into play once there is an insurance taken in that regard.
Yes.
So, wasn't an insurance taken as regards the personal cover, as regards
The personal cover premium is already normally charged in the policy. It's in the multiple of 50 rupees at that point of time, which would get a cover of 1 lakh of rupees. So if 100 rupees is paid as a premium for PA cover, then it will be 2 lakhs. Likewise, if the owner wants an extension of the coverage, then he can go to any amount.
any amount. So, it will be limited to the amount which is being there.
Yes.
The remaining will be the owner.
Remaining will be the owner.
Or is it that irrespective of that, the insurer has to pay?
No, my lord. The Ram Khiladi is very clear on that, my lord. Ram Khiladi, the judgment of Ram Khiladi, my lord, 2022 SCC says that PA coverage is a contractual
2020,
2 SCC 550, my lord.
what does he say? Where is it?
Yeah. 9 and 10 paragraph. Let me see. Clearly, yeah.
Paragraph 9 and 10.
9 and
Yes,
10, my
nine.
lord.
Whether the deceased not being a third party to the vehicle, number so and so being in the shoes of the owner can maintain the claim under section 163A of the Act from the owner of the said vehicle.
Mobile money card.
It is true that in a claim under section 9.5, there is no need for the claimant to plead or establish the negligence and or the debt in respect of which the claim petition is sought to be established under due to a wrongful act, neglect of default of the owner of so and so. It is also true that a claim petition under so and so is based on the principle of no fault liability. However, at the same time, the deceased has to be a third party and cannot maintain a claim under section 163A against the owner oblique insured of the vehicle, which is borrowed by him as he will be in the shoes of the owner, and he cannot maintain a claim under section 163A of the Act against the owner and the insurer of the vehicle bearing registration. In the present case, the party was governed by the contract of insurance, and under the contract of insurance, the liability of the insurance company would be qua the third party only. In the present case, as observed here in above, the deceased cannot be said to be a third party with respect to the insured vehicle bearing so and so. There cannot be any dispute that the liability of the insurance company would be as per the terms and conditions as held by so and so, and insurance covers the liability incurred by the insured in respect to the so-and-so to any person, including the owner of the goods or so-and-so carried in the vehicle or damage to any property of a third party caused by a so-and-so of the way. In the same way, it was further held that this court that the section does not require an insurance to assume risk for death or remand to the owner of the vehicle. In view of the above and for the reasons stated in the present case that the claim under so-and-so was made only against the owner and the insurance company of the vehicle which was being driven by the deceased himself as borrower of the vehicle from the owner of the Iman and he could be in the shoes of the owner, the High Court has rightly observed so-and-so. So now this is the heir, Ram Khilari. How does this court take note of? So here there is no decision in Wakia Afri.
My lord, in paragraph 14, the Ram Khilari, my lord, it was
No, it's okay, but there is no decision.
no decision as such.
The decision could not have been taken.
Yes, my lord.
So merely a reference being to the Supreme, to the another bench. It matters. So this Ram Khilari is the judgment on the point. And what about the wife? Who is the
Wife,
other
my lord,
claimant?
my lord, she is the wife of the owner.
And she suffered injuries.
Injuries, fracture injuries on hand and hip injuries.
So that will be only quantified to the extent of her injuries.
Right.
But is it only 15,000?
50,000, 50.
Why are you saying 5,000, 50,000?
5,000 has, 50,000 has been awarded, man.
Understood, but
As per the act, if it goes under the act, then it is only 15,000 limited.
15,000. Let us see this. Second schedule says this is general damages in case of ear. And it is not a case of ear. Amount of earn shall not be less than 50,000. If it is a case of fatal accident, it cannot be less than 50,000.
Yes, 50. That has now been,
But anyways, let us do one thing, calculation. Age of the victim was, what was the age of the victim?
25 years, my lord.
Yeah.
The son, my lord.
Then
The mother is 44 years old.
Was a law student and was doing some
Then,
PCO business.
25 years would be, no, forget about the mother. Then the multiply 18 has to be used
Yes,
and 21,000 has been taken to be the annual income. 18 into 404, what is this? Do you see the serial? How do you calculate it? That's right. Even assuming that the reference was proper, then also. It cannot exceed what is mentioned. Now, you see here, the court came to a categorical finding of 21,600.
What is it?
21,600 is the amount annual income. So it comes within the bracket of annual income. You have this 24,000. One is 18,000. Let's take the AR 24,000. Then it is above 25 years, not exceeding AR is 432 into 17. Now 432, how do you calculate this multiplier? What is this amount compensation in case? So 432 into 17.
My lord, these are all in case of death, my lord. My lord, understood.
432 into 17.
Yes,
Okay.
yes, my lord.
432
17
into 17. কিমান হ'ব অংক? 7 and 344.
7,344.
44. Now, if that is so, it has to be multiplied by what? But if on the other hand, it says that the amount of compensation shall not be less than 50,000, means
In that,
under no circumstances it could at any point of time reach 50,000.
my lord, it is the no fault, my lord. If even if the, my lord, accident is not proved, rash and negligence is not proved, under the provisions of 140, there is no fault liability. My lord, for 50,000 was required to be paid in case of death. In case of permanent disability also 50,000 was required to be paid by the insurance company. But where the rash and negligences had been proved and all the factors have been, my lord, established, then, my lord, the multiplier will come into play. Now everything is settled
Then you
after
see the
Sarla
note,
Burma.
the amount of compensation so arrived there. In the case of fatal accident, claims shall be reduced by 1/3 in consideration of the expenses which the victims would have incurred towards maintaining himself or herself. Now, I don't understand this table.
My lord, this
1,000.
is with regard to, my lord, it's this schedule is with regard to a, my lord, case where there is a death case, my lord. Taking the choosing the
That
multi,
I understand.
my lord,
Let us assume for a death.
my lord.
Means if we calculate this as per this also,
My lord, it is 1,000. It is in 1,000.
but
Rupees in thousands.
thousands.
So 4,32,000.
Huh?
It is 4,32,000. No, 432,000. So 4 lakh.
What?
Zero will come there.
Meaning thereby, how
That-
much it can go?
It can go up to 4,32,000 as per the schedule, second schedule, but only in the case of death. If it is a
Understood.
case of,
No,
if it is a case of
understood.
permanent disability, my lord, and that has been proved that he was permanently disabled, he has nothing to do, he cannot, my lord, even work in any occasion, then, my lord, this ratio will apply. Otherwise, my lord, the what
Which ratio?
this one, my lord, the death, in case of death, my lord, it will be presumed that he is a person who is unable to do
So
anything.
this 4,32,000 it would be.
Yes.
Then we here we don't need to then multiply it by any multiplication factor.
Yeah, the chart is very clear,
So the chart is given. So 21,600.
my lord,
500 is the amount.
my lord.
And if it is above 25 or below 25, it will be multiplied by 17.
17.
Here the chart is only for the conveyance.
My lord, for the
convenience.
convenience.
That it is calculated.
Yes, sir.
Hey, calculate her things.
432 into 17 crore. So 432.
Annually. It comes 367. It has to be divided by 3. 1,22,400 we deducted. Maybe 1/3 has to be deducted in this.
Okay, so this is in thousands.
My lord.
In this case, he could have at best got into what is his age?
25 years.
25. 25 will be not exceeding 25. Will be multiplied by 17.
Well,
$73 lakh 44,000.
3,65,000. So 3,65,000 has to be paid.
my lord, the deduction towards the personal expenses will also come, 1/3.
And what do you mean by the note?
The amount of compensation so arrived at in the case of fatal accident, claims shall be reduced by 1/3 in consideration of the expenses which the victim would have incurred towards maintaining himself had he been alive.
So then it will be divided by 1/3.
1/3.
So it will be around 1,21,000. Now, then further, you have the other funeral expenses and all.
Yes, other heads will come.
But under no circumstances, it will exceed 15,000 as the medical expenses.
Well,
So the mother would get only 15,000,
yes.
isn't it?
Well,
So even if the reference is being made, the liability at best would be of that of the insurer. That can be taken. And in the judgment delivered by Justice Emarsa, it is further mentioned that it is limited to the liability of the insurance for the owner or any driver. But in respect to third party, it is unlimited.
even if he was a paid driver, they could have established that he was a paid driver. Then, my lord, the WC Act, Workmen Compensation Act will come into play. So, well, in this case, my lord, what I have, my lord, found out is that the amount will be 3,67,200,
But
the compensation, and thereafter 1/3 will be deducted, which is 1,22,400. The amount comes to 2,44,800 rupees. And the liability of insurance company will be limited to the contract where the PA coverage was paid.
but how will the son get it? Son can't get it in view of the judgment of Justice Emarsa.
But when he steps into the shoes of the owner,
That is
So
what he was driving on his behalf.
so
of his father.
it is presumed that the coverage is extended to that
Yeah.
owner. My lord. So whatever coverage under the PA
Would the
is
owner
available,
get it?
my lord, the son will, the mother will get it, my lord. The
Who
dependent.
mother? Why will
Then-
the mother get it?
My lord, the dependent, my lord, who,
Normally in a motor accidents in a
Well-
personal when a person is alive, it is filed by that person.
representative case. My lord.
If it is the mother who files it, in this case,
Well,
will be only for the mother
Yeah.
for him.
Exactly, my lord. Lordship is correct.
So if it is filed on for him, he
Well-
cannot get if he steps into the shoes of him. As for the mother, she may get
She
it.
get it.
That is another
That is
thing.
a different aspect.
But here she cannot get it more than that. If the moment I say that he will get it, it will go contrary to the year because here in a representative capacity, the mother has filed on
Filed it.
behalf of the son.
Well.
So therefore, whether can the son get it? Mother separately is a different aspect. She may get it for the purpose of other aspect.
Well.
But in the case of the son, in view of the judgment in Ram Khilari, cannot get it.
Lordship is correct.
Disabled son, my lord, so filed up by the mother, and mother has also died.
The mother will have a right for her herself. For that, she will get 15,000. Because she's a driver out there, she's sitting out there under 163A, she will get it. Because of her injury. But as regards the son, how can the son get it? But the moment you see, in this claim petition which was filed there, more particularly the claim pertaining the claim petition filed by in MAC 75/2002, it was filed by the mother on behalf of the son.
Yes, yes, my lord. That's
So therefore, if the son can't get it, how will the representative get it?
correct, my lord.
Son will get it, no.
How will the son get it? Because the son was the driver. He lost the mechanical control. For that, it is a different thing. He may ask for certain other amounts out there before the insurance ombudsman. All these things are other aspects for which he may ask for. From the company, mechanical, or whatever may be, these are different things. But here the son will, the son cannot get it because he stepped into the shoes of his father. But for the other person, the mother, on her own account, she will get it. That too 15,000.
15,000 plus the other, if there are other,
What others?
there are some pain and suffering and some amounts.
The
towards
pain
that.
and suffering, okay, we'll give some. Heard Mr. R.K. Batra, the learned counsel, appearing on behalf of the petitioner. Mr. G.N. Sahewala, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent claimants in the appeals. Both the appeals are taken up for disposal by this common judgment and order, taking into account that both the appeals arises out of the same accident. Next. A vehicle bearing registration number, a Maruti car bearing registration number AS23A-5170, which belonged to one Muhammad Amanuddin, and insured with the appellant insurance company. Alauddin or Muhammad Amanuddin?
Alauddin, my lord. Amanuddin is the
Belongs to
son,
one,
injured son.
one Muhammad Alauddin. The respondent number 2 in the present proceedings was insured with the appellant insurance company the respondent number 2 son, namely, what is the name?
Lordship, son is not made a respondent in this. Amanuddin is the son,
Muhammad Amanuddin.
is the injured.
Anamuddin. Anamuddin. Respondent number 2 son, Muhammad Amanuddin. While driving the said vehicle, along with the claimant, that is his mother, and who were there? And the owner also.
Owner also, my lord.
And the respondent number 2 met with an accident at 11:30 a.m. on 24/3/2002 on a it is claimed that the said owner, the said accident happened on account of a mechanical defect in the car. For which the bearing of the vehicle, wheel of the vehicle, broke down suddenly. On account of the accident, Mohammed Anamuddin,
Now she hit appellant, my lord, one of the appellant, 1B. Because mother died now.
Mohammed Anamuddin, that is the person who suffered. No? On account of the accident, Mohammed Anamuddin suffered grievous injuries in his skull, for which he had to be taken, he had to be hospitalized. It is also claimed that Muhammad Anamuddin had become permanently disabled mentally and is in the custodial care of his parents, brothers, and relatives for day-to-day activities. The claimant, that is the mother of Muhammad Anamuddin, filed a claim petition before the learned member, Motor Accidents Claims Tribunal, Tinsukia, wherein her husband and the appellant insurance company were arrayed as parties. The said claim petition, in the said claim petition, the appellant, the mother, the claimant, as applicant, had sought for a compensation of rupees 33 lakhs 68,103. The said claim proceedings was registered and numbered as MAC case number 75/2002. was- The claimant further, on account of her own suffering, in view of the injury caused on account of the accident, also filed a separate application which was registered and before the Motor Accidents Claims Tribunal at Tinsukia, which was registered and numbered as MAC case number 80/2002, wherein the claimant sought for compensation to the tune of rupees 2,08,659. In the said claim proceedings, which was filed by the claimant, being MAC case number 80/2002, her husband, that is Mohammed Alauddin, and the appellant insurance company were arrayed as parties. The respondent, the husband of the claimant, in spite of receipt of the notice, did not participate, for which in both the proceedings, that is MAC case number 75/2002, as well as MAC case number 80/2022, were proceeded ex parte against the husband of the claimant. The appellant insurance company filed a written statement wherein, amongst the various defenses which are taken, challenge the maintainability of the said claim proceedings. In MAC case number 75/2002, on 12/12/2003, three issues were framed. That is, number one, whether the accident took place due to rash and negligent driving. Number two, has the claimant suffered mental disability, if so, to what extent? And number three, is the claimant entitled to the relief? If so, to what extent and against whom? The learned tribunal, by the impugned judgment and award dated 25/3/2004, held that the injured, held that the claimant, that the injured for whose benefit the claim proceedings were initiated, had driven the Maruti car bearing registration number AS23A-5170 in a rash and negligent manner. While deciding the issue number two, the learned tribunal arrived at a conclusion on the basis of the material evidence that the claimant, the injured, that is Mohammed so-and-so, Anamuddin, for whose benefit the claim proceedings were initiated, had suffered permanent disability. In respect to the third issue, the learned tribunal held that the claimant held that the claimant was entitled to an amount of rupees 12,56,103 along with interest at the rate of 9% from the date of filing of the claim application. Before further proceedings, this court now finds it relevant to take note of as to how the learned tribunal decided the claim proceedings being MSC case number 202, 80/2002. In the said proceedings, as stated above, the claimant, that is the mother of Muhammad Anamuddin, on account of the injuries suffered by her, had filed the said claim proceeding claiming compensation for herself. In the said claim proceeding, the learned tribunal also formulated 3 issues, that is, whether the accident, number 1, whether the accident took place due to rash and negligent driving, number 2, has the claimant suffered mental disability, if so, to what extent, and number 3, is the claimant entitled to the relief, if so, to what extent and against whom. Before deciding on the issues, before proceeding further, it is very relevant to take note of that the claimant's case in MSC case number 80/2002 was as to whether was that she suffered injury in her hand. The non-application of the mind in framing the issue is writ large, inasmuch as the issue number 2 was framed as to whether the claimant has suffered mental disability.
No, no, my lord. That was done in
That is what I am writing in.
my lord.
See the judgment in the other case, MSC 2, 80/2002.
Here whether the claimant suffered permanent disability.
Here it is mental disability.
That is in 75, my lord. Son's case.
This is in there. Mental disability. That is case. It is permanent disability. 8 line to side. To permanent disability. Huh? Anyways. Permanent disability. Bracket. If so, what extent? So he line to side. The learned tribunal, by the judgment and award dated 25/3/2024, held that the vehicle bearing registration number AS23A 5170 was driven by Muhammad Anamuddin in a rash and negligent manner. While deciding the issue number 2, the learned tribunal came to a finding that the claimant did not suffer from any kind of permanent disability. Insofar as the issue number 3, the learned tribunal, based upon the various documents, came to a finding that the claimant was entitled to a total sum of rupees 50,659 and directed the appellant insurance company to make payment of the said amount of rupees 5659.60 along with interest at the rate of 9% per annum from the date of filing of the claim petition till realization of the amounts. First, the records reveal that in pursuance to the judgments, awards passed in both the claim proceedings, two appeals were filed. The present two appeals were filed. First, in MAC case number 146 oblique 2004, the learned coordinate bench of this court, wide and order dated
Lordship is checking for the admission of the appeal.
by an order dated 30/9/2004, admitted the appeal. Similarly, in the case of in the other appeal being MSC case number, MSC appeal number 160 oblique 2004, by an order dated 30/9/2004, the appeal was admitted. First, heard Mr. In the backdrop of the above, let this court take note of the respective submissions on behalf of the parties. Mr. R.K. Batra, the learned counsel appearing on behalf of the appellant in both the appeals submitted that the judgment, the award dated 25/3/2004 in MSC case number 75 oblique 2002 cannot be sustained in law. Inasmuch as the learned tribunal completely, inasmuch as the learned tribunal had adjudicated the said proceedings as the proceedings under section 166 of the Motor Vehicles Act 1988, for short, the Act of 1988. The learned counsel submitted that in the instant in the case in MSC case number 75 oblique 2002, the injured was the driver of the vehicle, and he had taken the said vehicle from his father, who is the respondent number one in the respondent number two in the present proceedings. Under such circumstances, the injured, that is Muhammad Anamuddin, stepped into the shoes of his father, who was the owner of the vehicle, and as such could not have maintained the proceedings through his mother, that is the claimant, section 166 of the Motor Vehicle of the Act of 1988. The learned counsel further submitted that even a proceedings under section 163 capital A also could not have been maintained, taking into account that the injured Muhammad Anamuddin had taken the vehicle from his father and had stepped into the shoes of his father while driving the vehicle. Under such circumstances, the learned counsel, appearing on behalf of the petitioner, submitted that this issue have been well settled by the Supreme Court in the case of Ram Khilari and another versus United India Insurance Company and another, reported in 2022 SCC 550. And referred to paragraph number 9 and 9.5 of the said judgment. Kusto. The learned counsel further submitted that though a reference has been made by the a two judges bench have been made. Is that name? Where is the judgment? Judgment को कोई अपनी ना judgment.
Lordship is searching for the full bench, my lord.
Ah.
2026 3 SCC.
Admits that though that subsequently in the case of Wakia Afrin minor versus National Insurance Company Limited, reported in 2026 3 SCC 418, the issue as to whether the families of vehicle owners who die in self-accident can be allowed compensation under the no-fault liability provision under section 163A, or whether such claims are limited solely to third-party liability, have been referred to a larger bench. But such reference would not impact the case of the present appellant, would not impact the present proceedings, inasmuch as the judgment in the case of Ram Khilari and another, Supra, already holds the field in that regard. The learned counsel further submitted that in respect to the award dated 25/3/2004 in MSC case number 80/2002, The learned tribunal have again committed a gross error in adjudicating the said proceedings in a manner similar to a proceedings under section 166 of the Act of 1988. The learned counsel submit that at best the case would come under section 163A of the Act of 1988, and taking into account that there has been injury caused to the claimant in MSC case number 80/2002, the liability would be limited to the extent mentioned in the second schedule to the Act of 1988, isn't it? What is your submission? It's difficult for me even to contemplate.
My submission was that the matter has been referred to, that is why.
That is okay, but how do you take care of the proceedings was taken as a 166? What is your
That,
submission?
my lord, your lordships can take it under 163, that this court has the power, my lord.
It's okay. But what do you say about his case of 160? Because 166 is on a
166,
different.
my lord. 166, my lord, it should be taken up as 166, 63A.
The learned, Mr. G. N. Sahiwala, the learned senior counsel, submitted that submitted most fairly that the learned tribunal in both the cases would not have proceeded to decide the proceedings in the manner stipulated under section 166 of the Act of 1988. But the claimants are entitled to compensation. Claimant is entitled to the compensation for herself as well as for her son in terms with section 163A of the Act of 1988, which has to be carried out in terms with the determination of the compensation has to be carried out in terms with the second schedule to the Act of 1988. The learned senior counsel further referring to the judgment in the case of Wakia Afrin Supra submitted that the issue have been referred to the larger bench. Analysis and determination. This court have perused the awards passed in. The awards dated, impugn awards dated 25/3/2024. 2004. Passed in. Both the claim proceedings being claim proceedings number 75/2002 and being MSC case number 75/2002 and MSC case number 80/2002. Let this court analyze as to whether the learned tribunal was justified in passing the awards in both the claim proceedings, one by one. Number one, MSC case number 75/2002. In the instant proceeding, in the state proceeding, in these proceedings, the mother of the injured had filed the claim proceedings stating in the alia that the vehicle in question belongs to her husband, that is Muhammad Alauddin, and her son, that is Muhammad Anamuddin, was driving the said vehicle along with the claimant as well as the owner of the vehicle. The vehicle unfortunately, an accident occurred on account of a mechanical failure in the same vehicle, resulting in an accident, resulting in injuries to her son, who, even after treatment being meted out, have sustained permanent disability. In the backdrop of the above, if this court takes note of the issues which were framed by the learned tribunal and the manner in which the issues were decided by the learned tribunal, it will show that the learned tribunal was proceeding as if it was a proceedings under section 166 of the Act of 1988, without acknowledging that it was the fault of, it was the son of the owner who was driving the vehicle, and there being an accident occurred without the intervention of any third party. Under such circumstances, the manner in which the learned tribunal proceeded to decide the said claim proceeding, the instant claim proceeding, is contrary to the provisions of the Act of 1988. And as such, the impugned order dated 25/3/2004 in MSC case number 75/2002 cannot be sustained in law. It is relevant now to take note of that the whole section 166 of the Act of 1988 as to whether the claimant in MSC case number 75/2002 would have been entitled to any compensation for and on behalf of her son who had sustained permanent disability. In this regard, this court finds it relevant to take note of section 163 capital A of the Act of 1988, which is reproduced hereunder. A perusal, a perusal of the above quoted section would show that by the safe provision, a structured formula by the said provision, comma, payment of compensation on structured formula basis have been stipulated by mandating that the owner of a motor vehicle or the authorized insurer would be liable to pay compensation as indicated in the second schedule in the case of death or permanent disability due to the accident arising out of the use of the motor vehicle to the legal heir or the victim, as the case may be, in a claim made under subsection 1 of section 163A of the MVA. It further stipulates that in order to prove a claim of this nature, the claimant would not be required to plead or establish that a death or permanent disability in respect of which the claim had been made was due to an wrongful act or neglect or default of the owner of the vehicle concerned. Be it as it may, it is very relevant to take note of as to in MSC case number 75 oblique 2002, whether the claimant would be entitled to the compensation as already stated above. The present claim proceedings was filed by the mother in a representative capacity of the injured. The injured was the son of the owner, and he was therefore driving the vehicle by stepping into the shoes of his owner. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Oriental Insurance, in the case of Ram Khilari and another Supra, which was referred to by the learned counsel appearing on behalf of the appellant. The issue which is being posed in the instant proceedings seems to be no longer res intriga in view of the authoritative pronouncement of the Supreme Court in the case of Ram Khilari and another Supra. This aspect will be apparent from a perusal of paragraph number 9 as well as paragraph 9.5, taking into account that these two paragraphs are of relevance. The same are reproduced hereunder. From the above quoted paragraphs, it would be seen that from a perusal of the above quoted paragraph, more particularly, what is observed at paragraph number 9.5, it is clear as a noonday that in the case that when a vehicle is borrowed by a person, he steps into the shoes of the owner and he cannot maintain a claim under section 163A. Under such circumstances, it is therefore the opinion of this court that the claimant in once the 75, MAC case number 75/2002, even cannot maintain a proceedings under section 163A of the Act of 1988. In that view of the matter, the impugned judgment and award dated 25/3/2004 passed in MAC case number 75/2002 is required to be interfered with. Next heading, MAC case number 80/2002. In the instant case, the claimant have sought for compensation of an amount of rupees 2,08,000 report lekha ase saboti 2,08,000 on account of the injuries suffered by her in her hand on account of the accident. The learned tribunal, while deciding the issue number 2, the learned tribunal also adjudicated the instant proceedings as it is a proceedings under section 166 of the Act of 1988. First, in this regard, this court now finds it relevant to take note of the judgment of the Supreme Court in the case of Afrin to Wakia Afrin Supra. And what was referred to by the learned by the Supreme Court, by a 2 judges bench of the Supreme Court to a larger bench. The question therein is as to whether, the question which is referred is as to whether the families of the vehicle owners who die in self-accident can be allowed compensation under the no-fault liability provision under section 163A. This court have duly perused the observations made by the Supreme Court, more particularly at paragraph number 17 and 18, which are reproduced hereinunder. It is the opinion of this court that the Motor Vehicles Act 1988 is a beneficial legislation. In the instant case, the claimant had suffered injury on her hand. And it is the opinion of this court that as the claimant in the instant claim proceedings was neither the driver nor the owner, but a member of the family, would be entitled to the compensation under section 163A in terms with the second schedule for her injuries suffered, in terms with the second schedule to the Act of 1988. This court had duly taken note of the second schedule. And taking into account the observations so made in issue number, the findings so arrived at by the learned tribunal as regards the issue number 2, to the effect that there is no permanent disability, it is the opinion of this court that the claimant's in the in MAC case number 80/2002, at best could have been entitled to an amount of rupees 15,000 on account of expenses and a further amount of rupees 5,000 on account of grievous injuries. Accordingly, this court therefore disposes of both the appeals with the following observations and directions. The impugned judgment in a more dated 25/3/2004, passed in MAC case number 75/2002, is set aside and quashed. The impugned judgment in a more dated so-and-so 25/3/2004 in MAC case number 80/2002 stands modified in terms with the observations made herein above, thereby holding that the claimant in MAC case number 80/2002 would be only entitled to compensation in terms with section 163 capital A of the Act of 1988, read with the second schedule to the of the Act of 1988, and the compensation to which the claimant would be entitled to is to the tune of rupees 20,000 only. The said amount of rupees 20,000 be paid by the appellant insurance company to the claimant in MSC case number 80/2002 within a period of 4 weeks, along with interest at the rate of 9% from the date of filing of the claim proceedings. The said amount be deposited before the tribunal.
Tribe,
Records be returned.
obliged.
Lordship, we filed a affidavit in terms of the last order.
What was the permission granted for the block C?
G+4,
Residential? or-
residential.
We were operating the hotel, thereafter guest house, and thereafter Airbnb, which are closed. In pursuance of order, we are not running now at all.
That's
We
good.
stopped in pursuance of court's order.
So therefore, you have filed an affidavit, madam?
Yes, we have filed. Facing the site plan, the NOC, as well as the site inspection report of the GMDA. That was filed previously in 2020. In fact, on the last occasion, the court has also directed GMDA to bring the further details on some.
When did you file that affidavit?
Lordship, we filed it 10th.
That copy, I don't have it here. You have a copy?
As a copy? Mine is all marked. Yeah, send me a copy. Mine to Aru Kahani. But it's marked and I have made notes. This is a copy, but there are some jottings there. Musito file में डाल पाएगा.
Now, this is the permission which you,
This, on the basis of this, we got the permission.
but the fact remains that block C was never demolished.
Yes,
It remained as it is.
yes,
My question was on the last occasion as to whether block C
yes.
originally was constructed
Yes,
was, what was the permission type?
that time,
Block C was to be constructed by demolishing and lifting ground plus two.
Yes.
That
Yes.
ground plus two is still there. Alongside lordship, another building was.
that is again ground plus two. We got permission for ground plus four, but what we constructed was ground plus two. Block C. Oh, ground plus four. Ground plus four. And the owner is ground plus two. But that we have not demolished. আমার 35 দিছিলে আমার পর 28 আছে তো গ্রাউন্ড প্লাস 2 এইটো কিমান পায় নাজানো
Break the wall. That's easy. Market of the wall was not cheap.
Sir, we have access FAR.
If you break that wall, FR ends up.
Hmm.
All these three was together, sanction was from PWC.
It's a calculated report. Yeah, the site report doesn't talk about the wall. Site report doesn't talk about the wall. Huh? No. Site report doesn't talk about the wall. Bro. Site report doesn't talk about the marker wall. The marker wall. Yeah. It's subsequent. After 2013.
Board, I guess, is. Block C ground plus একেলগে sanction দিছে because then if FAI maybe there's a construct when you construct both and you just remove that
No,
one.
but in the site report, this will be it. We don't talk about the. We don't talk about the wall. Yes, sir. Site. About the marker. That's what I verified. Will be the 18 capital.
So the ground plus two, which you constructed, you're using it as a hotel.
Ground plus 4. 2 is the owners, landowners.
My question was whether ground plus four, which was there,
Ground plus 2 was their lordship.
or ground plus two. The ground plus two was the original existing.
Yes, lordship.
Now that original existing, what was the permission granted for that?
That we do not know. The landlady is not before law, and landowner is a party, but she has not appeared. GMD will know that.
And for the, then
Landowner, yes.
now, group C, matlab, building C block. So for C block, after issuing assessment was there, matlab.
No, your
After
permission.
issuing assessment, C block was constructed by the landlord itself, not by the builder. Builder part is separate part, that is the land couple, which the block A and B existing, that is separate land, separate dal and patta, and the land upon which the block C is existing, the separate dal and patta. That is separate, my lord. That was constructed by the landlord. Down to. And after passing order, my lord, I have, that was initially was for commercial purpose. After passing the order on 27/12/22, I have applied for conversion of the building status from commercial to residences. That is the, I have applied for. I have filed application for the GMD authority. Convert. In compliance with the order of the. But till that it was not converted, they are waiting for the final dispensation. blocks.
Now, who has given me this trace map?
My lord,
You have given.
this is the trace map of the,
This is a trace map pertaining to after the settlement operation.
sir,
Therefore, from here it is very difficult to find out, taking into account the dags and the patta numbers which were earlier there is different from these dags.
yes,
Now, whatever may be, you were supposed to demolish the G+2 and construct the G+4.
actually, my lord, that is, two blocks are there, actually, three blocks are there. G plus G block, block A, block B is another plot, and block C is existing in another plot.
Understood, Mr. You see, Block A, Block B, Block C
Blocks.
were permitted to be constructed over a plot of land at measuring 2 bigha, 1 katha, 4.6 lechas. Do you have any other land apart from that?
No, that is,
That is the truth. So therefore, in that land, you were supposed to demolish the G+2
yes.
and construct the G+4.
I have constructed G plus four, initially, originally I have constructed G plus four. G plus
No,
G
there
plus,
is there was an existing G+2 earlier.
that is the block D.
What? Where is Block
that
D?
was Block D. In this case, it is not related to this. Block existing, original existing is, was block G plus two. Thereafter, G plus C, thereafter, my lord, that builder has constructed G plus two building, A block and B block and plus C block. Three blocks.
So the builder had, you say the builder constructed the G+4.
G plus four. G plus four, that is not builder by, constructed by builder. That is myself.
So you constructed the G+4 based upon a permission which was granted, issued to whom?
The builder.
Permission was issued to Otis Infrastructure.
Owner.
No, the builder. Permission was issued to Otis Infrastructure. You are not Otis Infrastructure.
C, block C.
Mr. Council, you have to understand. Permission was to construct Block A, Block B, and Block C was only given to Otis Infrastructure, not to Nirupoma Board.
But assessment is there, my lord, that is in the issue in the name of, my lord, that or no objection was.
Show me the permission issued to you for constructing G+4.
That is, my lord, that I have submitted that
Where?
one. That is G
Is
plus
this
one.
one?
No, that is fire, my lord, and another one is also, that
Which
is,
one?
my lord, that fire insurance was, fire is, permission was there. But
I'm
they
not
have
on
not
fire.
given the,
Mr. Council, I'm not.
I
on
have applied for that.
Mr. Council, I am not in fire. I am asking you whether Nirupoma Boro
Yes,
has a permission in her name for constructing G+4.
that is fire permission is there, my lord. That's why it can be said that that was there, but they have not supplied the copy, assessment copy. I have applied, no,
I'm not on
permission
that.
copy also I have applied.
Mr. Council, try to understand.
Hello.
Should I tell you in Assamese,
Yes, no, my lord, that,
in English?
English, my lord,
Yes. Do you have a permission?
yes, my lord.
Does Nirupama Borough has a permission for constructing G+4
G plus.
from the GMD? Mr. Das.
Is
please.
apparently not. I'll explain. Mine is apparently not. G4 হবো নোৱাৰে তো এইটো তো OTs, this is OTs infrastructure.
My lord, my lord, yeah, here.
My lord, what it, one second, one second.
Floors are not mentioned.
One second. My lord, there are ABC block. It is a name of Otis infrastructure. They are the builder. He is owner, maybe he is a owner, but he has not built up. That is AB ground plus 6, ground plus 6. C is block is ground plus 4. That is not been constructed by the owner. It is builder who has constructed it.
Who constructed G+4?
No, I am not a builder.
It's not correct.
No, no.
The bill,
I-
I have not constructed.
No, no. Permission has been granted
Permission
to
is
Otis
mandate.
infrastructure. Permission has been granted to Otis infrastructure.
But we-
Permission.
But we have not constructed.
Yes.
Construction was,
What transpires from the affidavit of madam is there were 3 buildings
Yes.
which were to be constructed, out of which while constructing the G+2 was supposed to be demolished.
No.
Now, block A has been constructed, block B has been constructed by the builder.
Correct.
Thereupon some disputes must have happened for
Yes.
which the owner said, I won't allow you to construct, for which the owner constructed the G+.
Absolutely. That's correct.
That is what appears,
That's a,
Yes.
but the G+2 continues to remain. So unless you demolish G+2, how are you going to maintain the G+4?
they have informed, they have instructed me that there is separate assessment order, permission was granted for C block.
No, no, it
The
is
Nayak
a
will
block is
explain to you
G plus
that
4.
there is nothing. Is there anything? Ah, that is what?
That numbers are mentioned. The project comes toward below in the middle portion of block A and B, ground plus 6, block C, ground plus 4. So 3 buildings.
But there is no other permission. Matter ends.
My lord, in this, my lord, permission, first floor is mentioned. For block A, first floor, what is the area? The second floor area is mentioned. Third floor area is mentioned. Fourth floor area, that is for A block, B block, that were mentioned. But where is where for block C? But block C, there is no mention about the,
Mr. Council, it is mentioned there.
yes. Actually, what happened, my lord,
Yeah.
that permission was granted in their name, in the name of Otis, structures Otis. Subsequently, that block was, so C
Yes,
block was.
Mr.
constructed
Nayak,
by
why
the
haven't you taken action against them for block C?
Block C was constructed.
Now, if block C can be maintained by demolishing G+2, or if the area of block C is such, you have permitted them to construct a particular part, which taking into account the part. Now, if the block C can be maintained along with part of G+2 or something can be demolished, why if this is being not worked out?
Application for declaration of that portion filed for particular time. But in that situation, not the clause against subdivided. One wall has been constructed between A and B and C.
But there's a wall constructed, they'll demolish the wall. You see, at the end of the day, he would not mind demolishing the wall for saving his G+2 if it is permissible.
Yes, what
Only
is there,
thing is, can it be permissible or not?
As well as the 7th floor of A.
7th floor, you take it up. if the seventh floor has been illegal constructed, go ahead. Because I am not stopping anybody. This case I have been taking up more particularly pertaining to the G plus, the commercial, in spite of there being no commercial permission, they were running all these things. So this is being stopped. Now the question is, therefore I asked you, whether the G plus two, existing G plus two had a commercial permission or not. No. And in the assessment order, Mr. Counsel, in an assessment order, it cannot be commercial, domestic, anything, no, nothing. The permission has to be granted by the authorities. Understand?
Well, G plus four, so far G plus two, I have no, I have not been
You want to save G plus 4 or G plus 2?
plus two, that
Huh?
G plus two, G plus two.
Which one do you save?
I am, G plus two was, originally it was constructed by owner. Subsequently again, the permission was granted in the builder, name of builder, but construction was done by the owner.
Understood. What do you want to save? G plus 4 or G plus 2?
G plus two, whether they have permission or not, at that time, at the time of construction, they have got permission or not.
Lordship, in any event, even the G plus, as per the inspection, we have not, FAR has not been exhausted. FAR has not been exhausted. There's less construction.
So
So we would
therefore,
will
the
the-
thing is, therefore I am saying, why a proper application is not filed for regularization of that?
Yes.
Yes,
Right.
let them
Whether
fly.
it can be done.
Yes,
Now you see, now the new rules have come in.
yes.
Whatever rules was there, but at the time of regularization, the new rules can be very well looked into. Now with the new rules, many avenues are open. Now you see in Gauhati 10-storied buildings, the earlier 10-storied buildings you could never saw.
Never.
Nowadays, you everywhere you see the 10-story buildings, and more particularly when you are going over the flyover over the what you call that place, that the Jew Road flyover, you see the 10-story buildings, many 10-story buildings. So therefore, now things have changed. A G plus 6 in 2007 was a big thing.
Yes.
Yes.
2007 G plus 6 is a very big thing. We were told when I was a lawyer, somebody was saying that Numaligarh refinery has been given G plus 8. My goodness, G plus 8 in a seismic state.
Your lordship,
MMC
remember that
building.
Priyanka State,
Ah,
Priyanka State, that was
it is
what?
G plus 6.
No, that was given permission G plus 5 half.
5 half.
5
Three,
half.
4.5 actually.
6,
When,
7, 8, 9, 10, 11. I
I'm
think
I'm
that
just-
your lordship has the experience also. I had an
Madam was in, Madam
I was also an
Madam
experience
was
in this.
instrumental in the demolishing.
But that was demolished, my lord. That is true, that is demolished. What I am suggesting, my lord, what I am suggesting, you apply for regular. I told my learned friend, let him apply.
let
End
them
of the matter.
Yes.
Because they are
End of the
residing
matter,
over-
let him
Revert
apply.
petition.
Yes.
Family is residing over G plus two building.
Family, no family,
There is around-
Mr. Counsel, family, no family hardly matters. These type of equities, I don't have it. My question is only, if it can be permissible as per the new rules, taking into account the construction. Now, at that point of time, how the piling was done. You see, nowadays, every building which has a G plus 4 there has to be a piling. Now, at that point of time, it used to be done on the pillar foundation. Now, whether your G plus 4 was a pillar foundation, whether next to it can there be done, how much FAR is required? Because you see that there is a difference. When it comes to a commercial, the FAR is more. When it comes to a residential, the FAR is less. So therefore, these are things which needs to be looked into. So why you are not filing those applications before the DMDL?
I
Let
told
them
him.
consider.
Let him. He will file. I
And
told
you can't file it by your own. You have to take the help of them. Because without their help, you cannot.
We'll file.
Because with them only you can take the help for doing it.
Yes.
they will help.
We'll file lordship.
We'll help.
We'll file
We'll-
lordship, taking them into confidence.
So you file it before them, then let them consider. As per the existing laws, whether it is permissible or not.
Yes.
If it is not, I
Then
think the
not then-
GMDA should take action.
At the present zoning.
Right.
Present zoning like
And
that.
more particularly as number 7, Can it be maintained or not?
Ravanai.
See, the thing is like this. The land was, sale deeds have been made.
Yes, sales have been made.
So
All
say,
done.
the moment sale deeds have been made, these people, other people have also become joint owner of the
Right,
land.
correct,
Yes.
right.
Proportionate.
Proportion.
They are also the proportionate owner of the land in,
Proxy portion is concerned. Landowner is, has, he became the owner now. So there was a
no, no, one needs to see the sale deed.
Yes.
Now the sale deed is, when the sale deed is made, what is the plot of land where proportionate right have been sold? Anybody has a sale deed?
No.
Some petitioner will have it. Show me a sale
Okay,
deed.
flats bikri kora.
Agreement would not change materially anything, but the only thing is, no, that you see by way of a sale, whether the entire plot has been sold.
Huh?
Proportionate, right?
Proportionate, it's
Then
proportionate.
everybody has becomes a owner. Or is it only limited to the block A or block B?
Yeah.
That is the sale deed. Where do I find the sale deed? Here. Yes, Otis given to Lakshmi Ram Thakuria. Wait. Yes, now if you see, if we see the sale deed at page 50 of the WPC number 4389, have a look at it. The total block A, block B, block C was on a plot of land at measuring some 2 bighas or something.
Yes.
Now, if you see the sale deed here, it is only in all that piece and parcel of the plot of land at measuring 2 katha 14 lectures, which is only in respect to dark number 342. एक कागज अपन मशीन में मत लो,
Block A and B. There's block A and B.
which has now become 848. Yeah. Now block C is in 847.
847.
There they have bifurcated the land.
Mhm.
Okay. Good. See? So block A, they have bifurcated and put it in only 2 katha 14 lectures. The 2 bighas is the total land for which they sought for a permission. Now they have reduced it within 2 katha 14 lectures.
They made a wall, my
Madam, how are you going to do that? This will have
We
a
have not-
far-reaching consequence. Do you know this effect? The moment is there, it has to be contiguous with the, it is commensurate to the land. The far is there for the 6-story building. A 6-story building has a particular far being given. Now that far has, if it is residential, it is 1.75.
part and the what they have written.
Where do I get it?
In the permission, they've given, say, in the report, 1.71, 171.07. 171.07. page 99 of the affidavit which you filed.
What did they say? Block A, side, north, east.
FAR is 171.007.
No, it cannot be so. See, if it is 2 katha 14 lectures, 2 katha 14 lectures is
One question.
Mr. Naik, how much is the FAR for a residential? It is multiplied by 1.75. It is there in the rules. It is there
In the rules itself.
in the building rules. It is given how much is the residential FAR. Now then, this will have an impact upon the entire building.
Your lordship has passed an order in paragraph 3 because this is an impact because of they have subdivided, they have made a particular wall.
No,
No,
not
that's
wall.
you see,
No.
I think this is more for
No,
you-
what they have done is this. They have taken a permission for more than 2 bighas of land
right.
for construction of 3 buildings. Now, what they have sold, the proportional right which is being sold, is only 1 bigha. What about the remaining bighas? And if you have a proportionate right of a building, only to the extent of 2 katha 14 lectures, and if you see the corresponding FAR is 1.75, if I'm not wrong, it is 1.75 or 1.50. It has to be the total square feet has to be multiplied by 1.50 to get the total area permissible.
permissible, yes.
Now, if that area is less than that, the entire building will go.
Right.
All the ground plus 6, ground plus 6, all ground plus 6 will go. All are illegal.
But what I'm saying, you have mentioned about one agreement, the builder and the landowner. What's it like? Can't you see the arrangement there? This place for your.
Should be apartment.
And also will see how much land was bifurcated from the original.
No, that cannot be done. Because this, if it is done, this is absolutely illegal, madam. You know what is the FAR?
Yes.
Permissible FAR is, I think, 1.7, 1.50.
It's for apartment, it has to be
I
apartment
will give you
buildings.
the FAR.
Apartment
How
buildings.
much it is. At that point of time, the FAR is this.
Maximum coverage 50, minimum setback. Commercial is 1.75, 1.5, it should be 1.5.
1.5, na? So 1.5, you have it with, how much? 2,880 plus 2,880 plus 14 into 100.
No, I think what they have done,
144
Lordship,
into 1.8. That is the only area permissible.
So,
And if
Lordship,
that is the only area permissible, then how can you go beyond that?
no, I think what they have done in the sale deeds, they gave the proportional share.
No, you cannot.
No, I'm,
No, madam, you cannot.
no, one
The
cannot, but
moment
I
you are
think-
doing it, that you are reducing the building with the land. The land has to be commensurate with the building. Here it will be given with. I think this is this sale deed which have been done also. Why you are not approaching the RERA for that? Who is for the petitioner in the other case? Who is the petitioner for the other case? Why you are not approaching the RERA? Or RERA did not come into picture then?
Then RERA was not there, Lordship.
No, now. Where is Mr. TJ Mohanto, your senior counsel? They have changed it.
I am the petitioner, item number 2, Your Lordship. Writ petition number 7008.
Who appears for this Gautam Locker? Who are, you are led by whom?
DP Mandal. Lordship,
Who is your
Lordship,
senior?
I'm petitioner 4389, Your Lordship.
I'm here for, who is there for 4389? You are there. You
Yes,
don't
Your
know the
Lordship.
petition number also.
Lordship, my
goodness,
senior is there,
God
Your
will
Lordship.
help you.
DP Mandal.
Huh?
DP Mandal.
EP?
DP Mandal.
He is not here.
No, Your Lordship.
I think why should we continue with this type of person who doesn't know head and tail about the matter? He doesn't know what is the number. And we trust the government will took it. We take it up and demolish what is required. Part. Regulation of so-and-so industrial zone apartment building. This is apartment buildings. Minimum setback so-and-so, regulation of so-and-so. Building residential. Residential minimum is high density. The man relax the year with the following condition. Per 100. Per medium density 125. Minimum plot. And this will come under the high density. Kalibara.
I have to speak a specification, probably it will come.
Then it, the far is 100. 100 or maximum it can go to high, medium is 125. It is only for commercial, it is 175. This is given for permission, residential. So therefore, it cannot be that. Minimum plot size for residential use. R is high density is 225. Medium is 175. And low is 125 and the coverage has to be 60, 60, 60. That means with 2 kata 14 letters, how can there be a G plus 6?
What was bigger? That is why.
No, that is what. I think you need to demolish all the 3 buildings.
I think it's the 1998 bylaws which will apply.
Obviously, I am reading the 98 only. I'm not reading, I know because you have got it around 2007. Read it anyway. It's 1 o'clock. I won't spoil your lunch at page 401. Give it to madam. We'll have it in the second half.
Building bylaws, because that came into effect on the 1st of March 2000.
Okay, what is the then FR?
Then the FR lordship up to 4.4 meters road width, FR is 100, 4.5 to 7.9 is 175, and above 8 meters is 200.
But Mr. Counsel, Madam, wait. How would the petitioner maintain the instant restitution when they have no relation in respect to the other lands which falls in Block C? Yes. What is your right over Block C land? You have admittedly entered into a sale deed. There is a signature out there. Your land is within 2 kata 14 lectures, which is not part of Block C land. So Block C, they construct, do whatever field they do, that is their lookout. Who are you? Cleaned it, madam. I would have understood if it was the proportionate share being given in respect to the entire land. That is not what has been given. Your right is only limited to 2 kata 14 lectures. How are you going to maintain this repetition? Argue.
Lordship.
Argue.
Lordship. May I please, Your Lordship.
Yes.
Lordship, I am unknown to this matter, Your Lordship.
Then no
My senior was there.
petitioner.
My senior was there earlier, Your Lordship, but due to some uncertain circumstances, he went to his son's school, Your Lordship.
Huh?
He went to his son's school, your lordship.
How is it
Some
relevant?
uncertain situation has arisen, your lordship.
Yes, Mr. Naik. How is it permissible for them to initiate a proceedings when they have nothing to do as regards the land of Block C?
There it is still prevails for respect of the
Seventh floor is okay, but what about Block C? They have
blocks because of giving of the data.
we are not concerned to that effect because of the fact their right in the sale deed is limited to 2 kata 14 lectures. So therefore, whether they get or not, that is their lookout. For that, they have to go for rectification of the sale deed. On the basis of the seal deed, how can they get a occupancy certificate? That's their lookout. But can these courts override or set aside this seal deed? No. We don't have the power. For that, they need to do it. With closed eyes or open eyes, they have signed this document, the sale deed. So therefore, they don't have the jurisdiction in this instant proceedings. Seventh floor, you do whatever you feel like. Not on that, but what about the Block C? Block C he has no jurisdiction authority to question it. It will be he is not a person aggrieved.
And your lordship, I have gone through the order, your lordship, just now. There I have found that your honorable court was pleased to pass your order upon response number 10 to file an affidavit, your lordship. if I'm
They
not
filed the
mistaken.
affidavit on 1/8 they have filed the affidavit. 1/8 or 10/8? 10/8 they have filed the affidavit. I have looked into the affidavit. The affidavit contains 4 annexures. All these things I have looked into.
Lordship, and
Nothing. No case.
lordship, by virtue of
No case. So we should dismiss your petition.
lordship, lordship, last chance, your lordship, my senior will be there on the due to some
What do you say?
I'm sorry, my.
What do you say on this aspect?
This lordship is right, my lord, that this how it is maintainable.
How is
This
the
particular
repetition
petition is
maintainable?
maintainable.
Because
The
they,
concern about two,
unless they challenge the sale deed,
right?
the sale deed only says 2 kata 14 lectures. This is not a proportional land.
Right.
So if Block C is being constructed anywhere else, it is for the GMDA to do whatever they feel like. Why should this court intervene
If
at
there,
their behest?
if there is a violation also, they have to look into it. Why your lordship will look into it?
They are not on that.
But
Why
your
should
lordship is
put
looking
them
into whether the writ
pass
petition.
any interim orders directing them not to have block commercial and all? They have the power. They will enforce it. Why should this court look into this?
lordship, I'm unknown to the fact, your lordship, because my senior is due to some uncertain condition, he went to his son's school, your lordship. But I have gone through the synopsis, your lordship. There I have found, your lordship, that uh, your lordship, there is a illegal construction upon
Illegal
by the
construction
response
where?
number
The
illegal-
7th floor.
7th floor, block number A, your lordship. Illegal
Then
construction
illegal
by
construction, let the GMDA do whatever they feel
Lordship.
like. But you have nothing to do with Block C.
block A, lordship, block A.
You have nothing to do with Block. Your right is limited to 2 kata 14 lectures in Block A. That's over.
Lordship.
We are only concerned about these 2 persons.
Lordship, last chance may be given, your lordship.
I think on the next date we finish it off,
Lordship.
dismiss his writ petition, or allow his writ petition as regards 7th, and asking the GMDA to look into it, and remaining we close it. What is the other writ petitions for? Gautam Lokkar, who is he? For the same person. Then
Lordship.
Papuri Soikia, who is he? Yes, what is that case for?
Your lordship, my grievance is that the occupancy certificate were cancelled. And the builder could not pay the fine that it was supposed to pay, your lordship. There was a fine imposed upon the builder. They could not pay it on time, your lordship. That's why our occupancy certificates could not be issued.
So Take it up before the civil court. Why should this court look into it? The dispute between you and the builder. Why should this court look into this? If there was a statutory violation committed by them, yes, as regards block set, the above 7th floor, obviously this court will pass an order that if it is illegal for the GMDA to take an action, whatever it is, and GMDA has the power. Why should this court ask them to demolish or not to demolish? They have the power. We will only ask them to look into it. As regards third thing is not getting the occupancy certificate, obviously. How can you get an occupancy certificate when the building was constructed or the permission was granted for 4 kathas of land, of which the building now stands at 2 katha 14 lectures of land. You are in block A.
I am for for block A and B. I am for the residents. Some are residing in block A and some in block B.
So block A, show me one of your sale deeds. Hey, two item next item.
Sale deeds starts from 49. Yeah, 49. The sale deeds, Your Lordship, starts from page number 49.
The second writ petition. Yes. Sale deed is.
Mm.
This is also 2 katha 14 lectures. The other is again. All these are block A.
A and B, Your Lordship.
All these are block A. This is the block B. Block B is also in the same land. It
Yes,
is
sir.
in different dark number 342, 846, 848, new. So it's a different plot of land, but this is 2 katha 14 lectures. Obviously, you won't get the occupancy certificate, what has been done by the builder. But you have opened it with open eye.
But Your Lordship, that was a compoundable offense. And the builder was directed to pay a fine, Your Lordship,
How much?
22 lakhs.
And why the builder is not paying, madam?
That was a fine for regularizing the 7th floor. 7th floor.
That was 7th floor.
7th floor.
Not for the other one.
No, only for the 7th floor. And that time I didn't have money, I couldn't.
2000.
And is the GMDA going to issue the occupancy certificate if they pay the 22 lakhs? Of the 7th floor, 22 lakhs, you will regularize.
But for that purpose also, the plot of area is to be expanded.
No, but that
Well, where is the area?
Auction. 129. No. 131.
It is 008, page number 131. The letter is there.
Your agreement for sale also only refers to a bigger plot of land, where the construction will be of is 2 katha 14 lectures of land. Okay. You, you do one thing. Get your instructions from your client for demolishing the wall.
So far, my lord, we got two building. It is the NOC, my lord, issued in the year,
Mr. Counsel,
my lord,
you want to protect your property or not?
my lord,
Do you want to protect your property or not?
I want to protect my lord.
Then demolishing the wall is a better option, don't you think so?
My lord, I'm ready to
Get your instructions on that.
demolish, I will.
Because then that would be a compliant and then, because as per
Yes.
the GMDA, if you break that wall, your G+4, G+2 will come within it.
My lord,
So then demolish it,
I'm ready to demolish. My lord.
let it be there.
Well,
Because there is still
yes, my lord.
another, an area of 752.43 square meters remains unconstructed. So your thing gets
Yes,
saved.
I'm ready to demolish. my
So you do that
lord.
and ask
I
for
told that
commercial or whatever permission is there. They don't have a right on that. And as regards the occupancy certificate, what they are saying out there to that effect is they want to get you can't get the occupancy certificate unless and until the builder, your sale deeds are rectified. Because your sale deeds have a problem. It is on 7 katha, 2 katha 14 lectures of land. And at the time of agreement also it was 2 katha 14 lectures. And if it is 2 katha 14 lectures is block A, the land does not commensurate with the size of the building. You have a big problem on that. You have need to file a civil suit, do whatever you feel like you need to do something against the builder. Not here. And as regards block C, you have no business. And what is Mr. Fukon's case?
We are together. We are together.
What is that? Two senior advocates together, why?
In fact, my lord, started was the fact that when the building was constructed.
I'm here.
Yes. I'm sorry. I just surprised your lordship what had happened. A and B was built by the builder. We built it. Subsequently, we had a problem, financial problem. We could not build C. So we got into an agreement with the owner and said, we will not be able to do this. So we are giving it back to you. So one of the objections that came was that when the license and building was given to me, I could not have perhaps transferred my right back to the owner to do whatever is required to be done. Now that's a subject matter, my lord, that was raised but never settled. When I couldn't do it, the owner took the responsibility of building the G+4. Obviously, my lord, the map that I have given identifies the fact that G+4 could only be built when G+2 is first demolished. That is in terms of the map that I have given to your lordships. That was built by them. In that, the owner said that we want to keep it demarcated, not by any judicial order or an order by an authority, but to keep her part separate. She had built that wall. Now, in terms of your lordship's the thing has fallen down, it's absolutely right. You cannot have a building on 2 quarters of G+6. Is absolutely right, because the initial permissions were not on that. It was on the entire land, which is 2 bighas of land. This was created subsequently, and therefore that problem arose, that we could not complete it and they built it. And I had no control on it. I couldn't do it. It's a fact which is admitted, and agreement has also been executed to that effect.
You have got a
Subsequent,
builder?
yes,
Tell me one thing.
yes, ma'am,
How did you construct the G+6
yes.
on 2 katha 14 lectures of land?
That is a mistake which has happened, my lord, which we have identified now. Your lordships are right. That's why I'm saying, my lord, that's a mistake which happened, because the sale deeds
Is
had
there
to be
no-
executed on the entire
So
land.
entered into the agreement also,
Yes, my lord, that is a mistake.
2 katha 14 lectures.
Yes, my lord, absolutely right. That's why I'm saying, my
So
lord, it's
your
a mistake.
very construction and thereby selling the proportionate right only in
Yes.
respect of 2 katha 14 lectures and not the remaining
Absolutely
land,
right. That's a mistake.
takes the entire building.
Absolutely
in a
right.
very
I completely agree, my.
Yeah.
There's no dispute on that fact. And that now, when we have seeing it now, we realize that this is a mistake that happened. The fact still
But
remains.
that seems to be intentionally done.
My lord,
Ye- no, why I tell you why? Because what has happened subsequently is that this particular plot of 2 katha 14 lectures is now being brought within the ambit of the new settlement 848,
yes,
which is also mentioned in your sale deeds,
yes,
which is also mentioned in your agreement for sale, meaning thereby at the time of entering into the agreement also, you had it in your mind that you were only going to use 2 kata 14 lectures for that building and accordingly sell the proportionate share only in respect to this. Don't you think that this is the case for demolishing of all the buildings?
I would not go beyond that.
We follow as per Priyanka.
I completely agree to what your lordships are saying.
Responsible for the judgment. So we follow as per Priyanka, ask them to demolish at your
No,
cost.
may I
And
just explain
before
this, my lord?
demolishing of that,
My lord.
ask all the people to file suits against you for the recovery of that amount.
My lord, yeah. May I say this, my lord? If the intent of the
You
builder,
are
my lord,
responsible for that judgment, so obviously she knows better.
to the two quatas of land that my lords are mentioning, I may not have been a part when the execution of the deeds must have happened.
Why not?
Because
Who?
my lord, I gave up because I was not doing anything after that.
Oh,
My
no,
construction
no,
happened,
no,
the agreements were executed, my lord, subsequently.
Oh.
So that role, my lord, I'll have to ascertain because I am not very sure, because I will have to take instruction on that. But in that phase, my lord, I was out of that construction thing. I was no more there available.
Is Anil Kumar Jain.
I'm not aware of it, my lord, Anil Kumar Jain. That discrepancies, my lord, is right. I have seen it. But there is a situation that I was not existingly available for that thing.
Because these sale deeds were executed by Otis Infrastructure.
Yes.
That means
No, my lord, Otis is my company. The problem that happened is, my lord, I was not in the realm of affairs.
I'm not
Your
concerned.
lordships are absolutely right when you say that
concerned to that
2.14 has
effect,
been
whether
mentioned
you
instead
the-
of that.
the-
That is an
the-
absolute error which has happened.
Yes, Otis Infrastructure is a proprietorship firm.
Yes, my lord.
So if it is the proprietorship firm name is only a trade name.
Yes.
So remaining is actually you. So therefore, when you have opened with women eyes, have signed it as a proprietor of Otis, Suresh Kumar Jaiswal.
Yes.
Obviously, you are
My lord, I agree.
responsible.
That's why I'm saying, my
I
lord, there
think
could
we
have been a situation like that.
Them asking you to demolish all
2.14
the buildings and then file suits for recovery for them. That is the only way out.
No, that is only, my lord, if the spec still remains to be decided by your lordship, is whether it is in the 2.14 or is it the entire part? Because
it
the
is
construction
the
happened, my
same.
lord, the permission was for the entire land.
Understood, but why did you execute the sale deed giving
That is-
proportionate share only for 2 cut of
That
14 letters?
is an inadvertent mistake, my lord, which I'm admitting right now, that there was a mistake that
So
has
what
happened.
is the rectification you are going to do?
We will, as I said, my lord, I'll take the instruction on that. I do not have the instruction as of now, but it is right. Let me come back to your lordship with this instruction. I agree to that, your lordship. There's a mistake.
It
should
will
not have been
now
executed.
require a rectification.
Absolutely, absolutely right, my lord. I agree to it. My only thing is I need to take the instruction on that part. Why was it done? I do not know about it. So I would not like to make a
But do you
statement.
have now the power of attorney for 2 katha 2 bighas land
My lord, the
after
question,
the sale deed having been executed?
we'll have to look into that, my lord. I'll also have to look into that, my lord. I agree to that problem, but let me just come back to your
Your
lordship with this.
petition is for what?
Mine was in relation to that on that.
7th floor.
No, my lord. I am the builder. I was in regards to this. 240, my lord, is the writ petition.
What is that for?
Yes, my lord. Page 39, my lord.
Why have you filed that?
Yes, my lord. That to cause that show cause notice was issued.
For?
That is at page 39. Is it the show cause notice was issued to the builder, my lord, for not completing certain activities that happened during that period. I came up to say that the order that was passed on 6/11 giving me the right to build was also subsequently cancelled. I said, please don't do that. And I came against a show cause notice of 9/11/2022.
Well-
May I just state it, my lord?
Ekone diok aji eta dismiss koru diok. So, okay, one dismissal, we do it today. Okay. Show cause, where is the show cause?
Yes, my lord. Yeah. My lord, 73. 9/11.
And subsequently, I gave a letter, my lord, which is referred at page 71.
No, there are
Asking
two,
for a-
no, there are two parts.
Yes, ma'am.
One is the seventh floor and
Yes.
the other is
C.
C.
Yes.
C you have not done, no problem with
Yes,
that.
C I
You'll
have
take care
not.
of it in the
Yes.
other writ petition. But as regards seventh floor,
Yes.
you reply, matter
My
of
lord,
fact.
may I just take your lordships to page 71 for a minute of the same writ petition? 71. If your lordship sees the subject matter, my lord, your proposal for occupancy certificates 36-2000. With reference to the above, your proposal for occupancy certificate is approved by the authority for block A and B. In this regard, you are requested to deposit an amount of 22 lakhs for as penalty for excess area constructed and renewal fees. You are therefore requested to fulfill in 10 days' time. So when this notices came, I said, my lord, there was a problem. I explained to what happened. I said, okay, if this is to be when be done, if it is an irregularity, I'm ready to do it. However, since I was facing a financial problems, I could not do this.
Now you are better.
I am not. I'm
Then-
absolutely not. In fact, in most of the situations, I'm not even in the realm of the
And
affairs.
the seventh floor building
Belongs to Mr. Das's client.
Who is staying in the seventh floor?
Mr.
You.
Noba no, my lord, I don't stay there at all. Noba Borkotuki.
You have sold it.
Yes, I not sold it, my lord, because it was taken away later. He came in later, and the sale deed happened much later. So I was not in the realm of the affairs, but he took 7th floor
From?
from us, but I did not give him the permission for a simple reason, my lord. What happened is, I said the permission is only 6 plus ground plus 6. So the 7th floor was not available to him. So he went ahead and bought a sale deed, done. Obviously, I was put into some kind of a duress, but I had to do it and give it to him.
Did you file an FIR?
No, my lord, I did
Did
not.
you file a suit?
No, my lord, I
Then
did not.
Don't come up with this type of.
No, I'm only saying, my lord, the situation that I was at that particular point of time. Point of time.
That cannot happen.
So
we
this
do
was
one
what
thing.
was asked to be regularized, my lord, and
Okay,
this
no,
is the
no,
reason.
on the next date, you take up seventh floor. But this document shows that you are otherwise going to give him the occupancy certificate. You are ready to give A and B. Huh? No, that he will break it. He will break that. Once that is broken out, I think that can be done. Huh?
This unauthorized subdivision is done. That's it, and the builder apart. They entered into an agreement.
No, it's okay. No, I'm putting it into in the order. They will demolish, file an undertaking for demolition. Huh? For that wall. For wall, they will demolish. And then I will close it. Their petition, I will close it that they have no locus unless the sale deeds are not rectified.
There is prohibition that
I give you the liberty to take action against the seventh floor.
that goes there.
I give you the liberty for taking action against the seventh floor.
So it should not be like once the occupancy certificate is done, and the seventh floor is regularized, they will again construct a wall.
You have the power to demolish. You know that at whose cost you will know it very well. That can be done. So in view of the council not being there, we adjourn the matter. And on the next date, this is the order we are passing it. We are dismissing your writ petition as regards Quadr Block C. Your only grievance as regards the seventh floor, we are passing order. As regards him, the occupancy certificate, if it is not given, it is requirement of law, then whether RERA would apply, or if RERA does not apply, then we'll pass an order. You look into it as to whether RERA can be brought into the picture. Number two. As regards the Mr. Phukon's case, you do whatever you feel like. It is absolutely encourages type of litigation. Hearing almost complete, this court have duly heard the learned counsels appearing on behalf of the party. However, on account of the counsel appearing on behalf of the petitioner in WPC number 4389/2020, having left the court on account of certain urgent reasons, the hearing insofar of as the writ petitioner in WPC number 4389/2020 remains inconclusive. So accordingly list this matter on August 2026 at the top of the list for final disposal. In the meantime, this court directs your respondent number
That's for 8.
7,
7 and 8.
7 and 8 is directed to file an undertaking as to whether they would like to demolish the wall which is standing in between block A and B with the block C. You file that. We'll take care of your situation. Otherwise, because of the wall, your building should not. Okay.
Also cover my statement.
Which one to dismiss? Which one?
I'm saying in regards to G+6, if that wall is gone, gives me the FR that qualifies in that. I will still have to do my correction in regards to the same. That's not difficult in this.
That we'll take care of. Let first get it dismissed. The wall undertaking, let us get it. And once we get that thing, this can be regularized.
My lord, by very lighter vein, all three had very light meal today. We couldn't have a heavy meal today.
Why?
You could have.
And for the, my lord, respond number 7 and 8 for in this petition number, my lord, 70083.
Who are you the?
Different, my lord.
Hey, to know. Hey,
Proposition
what is his position in WPC number 4389? Just find it out and tell me. Otherwise, this will again, because of him, I don't want to bring that.
Later, so they came later into the picture.
Whatever may be, they are parties there. 7389.
Yes. 12, my
What is the name?
Rabha.
Yes.
Yes.
For respond number 12 in WPC number 12. You filed the undertaking there.
Replay, please.
Yes. What is your instruction?
Lordship, just may I pray for Lordship? In this matter, B. Gogu is appearing, Lordship. Just away, Lordship. He will coming after some time, Lordship. After some time.
What are these additional affidavits?
Legal record tender documents, my lord, relating to that board L1 board. By the second affidavit, my lord, we are bringing on record that my lord retender. The retender notice, my lord, where I was evaluated as L1. Input number of words, I was evaluated as L1. Later on, my lord, they have issued the retender. By the second, it's an affidavit.
But we cannot interfere with the second tender notice. We will only interfere with the main order and accordingly direct them to again reconsider, taking into account that this is not there. If it is so, as per the instructions. Oh, yes. Hello, none has appeared on behalf of the petitioner as well as the respondent. Matter stands adjourned to be listed again on 27th of August. Yes, what is your argument? You are not, are you appearing in this matter?
Lordship, my senior Mr. H.K. Das is,
Where is he?
he's outside, Lordship, coming.
Okay,
Lordship.
none appears. You are appearing. Counsel for the Gauhati High Court having not been represented, list the matter on 27th of August. Next. We'll take your concern. I know what your appeal is pending. I know that. Don't worry. Because you see, the thing is, they are asking from the memorandum from these people. We'll look into it. Don't worry. Madam, I know that. I remember your case. Don't worry. Your appeal is pending before the secretary. Now, this secretary has asked the comments from the High Court. High Court has given the comments or not, I don't know. But we are also to look into it. What is the scope of the proceedings? Should there be an appeal in before the secretary or should it before the High Court? Because that is another very important aspect which needs to be dealt with. Taking into account the High Court, you see the order which is being passed is being passed by a district judge level grade 1 officer. Now here the officers out here, the registry will also be a grade 1 officer. So can it be done by them, the appeal, or should it be done by the High Court? These are questions which will needs to be looked into it. Anyways, the registry in the meantime has already sent it. Don't worry, I know that. None appears on behalf of the petitioner on court. List this matter again on
There is a interim.
24th of August.
No,
in case-
11, item 11.
No, you have missed the bus.
I was just coming from.
I
the
can't
other
help
court.
you. You have missed the bus. We have other matters. There are a lot of councils waiting. If you miss the bus, it is goes. If you want to do the hearing, we can have it at 5 o'clock. Otherwise, not no. You want to do it at around 5 o'clock, wait. Else, that is your lookout. But otherwise, you have missed the bus. Now, what is here in this matter?
Lordship, item number 12, it may be taken
Ah.
up today, Lordship, when there is an urgency and stay order is operating in this case, Lordship.
Okay, we are not
Regarding
extending. The council for the petitioner is not
Laundry
there.
service in the railway, Lordship.
Huh?
Laundry service in the railway, Lordship.
A laundry service. So
Yes, sir.
therefore, if the council for the petitioner is not present, we can't help it. So
Lordship.
the interim order is not till disposal.
Lordship?
The on-time order is only till the next date, isn't it?
Yes, Lordship. Because Lordship, further delay is affecting the Lordship, the work. Because,
If the petitioner is there, okay. We pass an order. So the council for the petitioner is not present where the matter is taken up. Full stop. Under such circumstances, the instant proceedings could not be the proceedings of the present petition could not be proceeded with. Because in the meantime, as there is an interim order, the further continuation of the interim order would not be in the interest of justice for which the interim order stands. This court is not inclined to extend the interim order. Counsel not present, what to write? Okay, list this matter again on 21st of August.
Lordship,
Oh, yes.
in this matter, I have submitted on behalf of the board. There was a process for reconsideration, but ultimately it didn't materialize in positive. So I leave it to your Lordship because ultimately it is with regard to the so cause and opportunity hasn't been granted to them to reply. Otherwise, if it so demands, we may be allowed to proceed after your Lordship passes this order.
এই আগত paragraph এই আগৰ paragraph first 23/6/2026 অৰ্ডাৰটো যোনটো আছে heard as বঠাকুৰ গুচাই দিব as দি দিব আৰু বাকী কেইটা চবৰে নাম দিব paragraph 2 পৰা সব এইখিনি দি paragraph number 9 লৈকে দি দিব তাৰপিছত লিখক where is that section 21 from the materials on record
Indeed.
it is seen. No, full stop. It is the specific case of the petitioner. That in terms with the proviso to section 21(4), the consent can be cancelled. The proviso to section 21(4) of the Air (Prevention and Control of Pollution) Act 1981, for short the Act of 1981. The consent can be cancelled. A reasonable opportunity of hearing has to be given to the person concerned. Second proviso, first one, second proviso. In the instant case, admittedly, there was no show cause notice issued to the petitioner. And abruptly, on 5/3/2024, the consent to operate, the consent to establish was cancelled, was
With-
withdrawn. In the previous segments of the instant order, this court have duly taken note of the difference between a consent to establish and consent to operate. Inasmuch as without a consent to operate, the petitioner could not have run the brick lane. Under such circumstances, there was no justification on the part of the respondent authorities under such circumstances. The respondent authorities, more particularly the respondent number 3,
Yes.
the respondent number 3 not only violated the second proviso to section 21(4) of the Act of 1981, but also acted in an arbitrary and unreasonable manner. Inasmuch as there was no such urgency to waive the basic necessity of the issuance of the show cause notice, which is otherwise the mandate of the second proviso to section 21(4) of the Act of 1981. Taking into account the above, this court therefore sets aside the impugned order dated 3/5/2024, whereby the respondent number 3 on behalf of the respondent number 2 issued the closure notice under section 5 of the Environment Protection Act 1986, read with section 31A of the Act of 1981. of 9181 paragraph 2 দিয়া আছে এবাৰ চাই ল'ব হা Next. In view of the interference with the order dated 31/3/2024, the consent to establish so issued by the respondent number 2 by the order dated 23/2/2024 which was valid for a period of 5 years revives. Accordingly, the writ petition therefore stands disposed of with the following observations and directions. Number 1, the impugned order dated 3/5/2024 issued by the respondent number 3 on behalf of the respondent number 2 is set aside and quashed. The consent number 2, the consent to establish issued by the respondent number 2 in favor of the respondent number 4 issued by the respondent number 2 by the order dated 23/2/2024 revives. Number 3, the period from 3/5/2024 till date shall be excluded while computing the period so mentioned in the consent to establish dated 23/2/2024.
And lots of, this order may not preclude us from going ahead with, after adopting the procedure.
Before parting with the record, this court, however, finds it relevant to observe that the interference of the order to the order dated 3/5/2024 is on the ground of non-compliance to the second proviso to section 21(4) of the Act of 1981, as well as on the ground that it was done in haste, in an arbitrary and an unreasonable manner. The setting aside of the order dated 3/5/2024, as well as the reviving of the consent to establish dated 23/2/2024, shall not preclude the respondent authorities, more particularly the respondent number 2 and 3, to take appropriate action if so permissible under law by the appropriate action in accordance with the provisions of the Act of 1981,
81.
read with the Environment Protection Act of 1986. The horse, the observation without the observations so made in the instant judgment shall not affect such course of action. No, your period is gone. We vacated the order, na? Can't help you. Do some other day, because otherwise the laundry is there. Others, they have also left. Can't help it. There was not even a single council out here to say that adjourn for the time being. Can't help it. Bus has gone.
Item 5 and 6.
Get hold of them. I will then consider. They are not here. None is here. I don't see anybody here. Yes, what is this?
But in this case, the respondent, they filed their appeal today, I served a copy. I filed a reply.
Who filed?
State government. Filed it today morning.
Who is respondent number 1, 2, 3?
1, 2, 3 loss. We have filed loss.
Who is respondent number 1, 2, 3?
1, 2, 3, we have filed loss.
Understood. But who is respondent number 1, 2, 3?
1, 2, 3 is
No,
the loss.
because I will, if Madam Udas was standing out there, I know that it is the government, state government.
Lordship.
But you are,
The
it's very
ministry-
difficult. You change your colors. Sometimes you become CCSE and sometimes state. So which one?
Ministry of
Or even
Commerce and-
sometimes the PP.
Ministry of Commerce and Industry, Lordship.
Huh?
Ministry of Commerce and Industry, Union of India, Lordship.
Union of India. So you have filed. Now state has filed.
State has
So
today morning filed, Lordship.
So that is what not the fair here. We have filed. How do I know that who, for whom you are representing?
Lordship.
It has been submitted that the respondent numbers five. Five had filed an affidavit in opposition today. The said affidavit is not on record. Mr. R. Sekhar, the learned counsel appearing on behalf of the petitioner, submits that he may be granted some time to file a reply. Full stop. List this matter on 28th of September 2026. In the meantime, the reply be filed.
Lordship.
Internet.
Challenge has been made on the selection of the private respondent, the post of process server. Basically, establishment Nogam. The selection process.
So the promotion of yours from grade 4 to process server. That was
I have challenged that. The selection of the promotion of the private respondent from grade 4 to process server, I put that in the challenge.
private respondent. Who is appearing for them? Anyways,
Someone has filed an affidavit, my lord, for the private respondent.
what is your case?
I have to find
Gauhati High Court's order. No, that I have got it. What is your case?
My lord, the peti-
You see, on what basis do you?
what happened in this matter? I'll just explain, my lord. Petitioner, he was initially appointed in the year 2013 as, my lord, office peon. The private respondent was initially appointed as, my lord, that is peon for officer. Both were appointed in the year 2013. Now the private.
Same date.
No, same selection process pursuant to the same advertisement.
Then you have to go as per the serial number.
No, now here, my lord, merit. Because there is a
Okay,
provision rule.
in
12.
merit. Who is higher in merit?
The private respondent scored higher marks than the petitioner, my lord. Accordingly, my lord, the seniority list was prepared wherein the private respondent was placed at serial number 1, my lord, in accordance with merit position, and taking into account that merit position, the promotion to the post of process server was made. Now, petitioner trying to make out a case that when in the year 2013, the selection was held, two different posts, two separate selection was held. And in the minutes, my lord, the resolution of the committee, my lord, there were two merit lists were shown. And the advertisement said that one candidate can apply for only one post. Our contention in affidavit is that, my lord, one written examination was held, one viva voce was held. So it was one examination. Since the posts were different, my lord, one candidate can apply for one post only. So the marks will have to be different.
But at the end of the day, all are grade 4.
All are grade 4, and the the private respondent, that is respondent number 5, he scored more marks than the petitioner. That is briefly the case. And
the promotion is, what is the criteria?
Seniority cum merit.
So both.
That is followed. Benchmark is there, my lord. Resolution I have annexed, my lord. They have
on
followed
the
the.
basis of seniority.
Exactly, my lord. Exactly. On the basis of seniority, they have given, my lord.
What about 5 and 6?
Respondent number.
6, what is there?
6, I don't think there is any involvement of 6.
He came first. Private 5.
No, the promotion was given to respondent number 5.
and 6 was in the waiting list. I'll just check, my lord. I'll just show.
I am third in position.
6 was serial number 2 in the for promotion to the post. He was basically in the waiting list, and he was at serial number 3, the petitioner.
But he, 6 is otherwise senior, as per the gradation list, no.
Yes,
Why have you put the 6 at number 2?
I'll just explain, my lord. Because 6 code
Six was also appointed on the same date.
yes, same selection process.
I'll take your lordship to just.
I'll
documents,
just
ma'am.
show the seniority list. May I just cross check?
How we were selected.
No, he was at serial number 2, my lord.
Although the petitioner have a first right of audience, let us get the facts from him. Then I can ask you,
No, why?
yes, why 6? Means that as you are not ready.
No, I'm sorry, my lord. I'll just
I can't help you.
no. I'll just place, my lord.
I think your right of audience being a senior counsel is not there. We give it to the petitioner
no.
counsel. Yes,
Lord,
Mr. Bhardwaj.
6 has nothing to do, my lord. 6 has nothing to do, but the respondent number 5 was selected. And
Understood.
petitioner
Why
was at
6
serial
have-
number 2.
Whether in the gradation list you have put the 6 above, because that is what
No,
he's challenging
no,
the
no,
gradation.
no, my lord. He
Yes,
was
Mr. Bhardwaj, tell me.
petitioner at serial number.
Take
I'm
your
sorry.
seat, you have not ready.
I have challenged the entire selection process. Now, since 6 was placed at 2, naturally I have to make him a party. That's why I have added him as a party. Now,
Understood. Why 6 was put at number 2?
one of the one of the records of selection was not made available to me, and I approached this court with only the appointment order, my lord.
Okay,
When-
now,
when
now
I filed
have,
the affidavit,
have they filed the affidavit?
yes, they have not annexed the comparative statement or anything. I mean, the
No, it's okay. I'm not on that. You have challenged the gradation list. Where is the gradation list?
the gradation list your lordship will find at the affidavit at page 215.
I see one judgment passed by me somewhere.
Yes,
What is
that
that
was
matter?
that was 218. Your lordship's judgment.
Ah,
That as per me has no relevance with them.
1289. Anyways, now gradation list is where?
This is 17/9/2025, page
Page?
217.
Gradation list. 217. Ah,
There's no waiting.
no, where's the gradation list? 217, no gradation. list.
Well, this was the gradation list.
217 is not the gradation. You don't know what are your page numbers.
217.
This has not been challenged as of now.
No, where's the gradation list I find? In which affidavit you have filed?
But in their affidavit number, the affidavit filed by the respondent number 1, 2, 3, and 4.
Filed on 6/6/26.
By whom?
By
the Gauhati High Court.
respondent number
36
1, 2, 3, and
2026.
4.
36 2026.
Yes, my lord.
And there you have enclosed one judgment of mine.
Correct, my lord.
Why?
My lord, it was relied on the ratio because the seniority will be as per the merit position.
Huh?
Seniority will be fixed as taking into consideration the merit position that has been held by your lordships in that judgment, my lord.
What did I hold? For processor?
No, it's a different post, but the ratio is laid down by your lords.
Oh, that is a different one. That is for seniority in respect to this on merit. And there was this particular MAC officer, MACT officer, he issued the letter to the appointment letter to that
Subsequently.
particular person later on. So he joined later, whereas he joined, but this is as per 12,
Para 18 and 19,
the 12, rule 12. Rule
Then
12
your lordship said
categorically
that-
says what happens, and if within 15 days he joins,
your lordships held that it was out of the same selection process because High Court, my lord, conducted the selection and sent it to the MACT. And MACT officer, my lord, on two separate dates, he issued the appointment letter and placing the other person to be senior, my lord. In that context, your lordships held that para 18.
no, Well, para 20, I said so, I remembered my judgment.
Yes, yes, my lord.
I said that 12 is to the effect that
Yes.
if he joins within 15 days from the date of issuance of the appointment letter, he gets his seniority on the basis of the merit.
Correct.
And then, I remember my. But here is a case that he joined later, but his appointment letter was also issued later. In this case. Anyways, where is the gradation list where you
But
have been?
he was, in this case, my lord, he was selected by the High Court. High Court sent a combined merit list. Out of that merit list, one person was.
Which case?
This annexure A2.
No, not necessary. I remember.
Fine.
My question is, where is the gradation list?
The page right before the judgment. The page right before the judgment.
Page?
Right before the judgment. 217.
No, page 98 is the judgment.
Hmm?
And then mark sheet is there, page 113. Are you saying about that?
No, lordship is seeing the, I think, private respondents.
No, it is being filed by respond number 5. Okay, he has filed.
That is the private respondent, my lord.
Page, your affidavit, page.
My affidavit starts from page 201.
Here is page 217.
Oh, wow. Yes. But 209 it starts. Anyways, where is that gradation list?
217.
To check your page properly, huh? Not in this manner. Minutes of the meeting is here.
Yes.
Where is the gradation list? Got it. Now, who is Hiranya Ballabh Bora?
This is the private respondent number 5.
5. So he is there. Now, what has happened is class 9. G2 Bora
That is the picture.
is number 2.
This number 2.
Yes.
Then Nipul Bonia, who is he?
That is the private respondent number 6.
Unnecessarily you have brought him. He's number 3. He has no relevance.
Still in the selection, now in the impugned selection process, he was placed at 2. I was placed at 3.
No,
Where?
That
So here it will be there, na? In the minutes of the selection. The minutes of the selection. And again, my judgment comes into the picture.
that particular document has not been provided by.
Service group, employee who has joined the service earlier.
No, there was no waiting list, my lord.
Waiting list, nothing.
There was no E2 resolution.
Now, why are you saying that he was put at number 6?
No, my lord, there was no waiting list.
I made that
Assuming.
yes, I made that statement on the instructions.
Oh, assumption. Now, therefore, where is the final minutes? Where the selection was carried out? Oh, the final minutes is not here.
Final minus is not there. I'll just check.
What type of affidavit is this? So we have to consider that there is no minutes. No
There is a
selection.
minus, my lord.
Hey, Hunoksin,
Names of
take out the judgment of 1988 4 SCC 543, paragraph 13 to life that down. We cannot take into consideration this type of affidavit. More particularly from the Gauhati High Court.
the minus 2.
543.
Well, I'll produce the records, my lord.
No. We'll presume that there is no minus.
No, there is minus.
No, we cannot. in view of this judgment?
Look, the minutes was there.
We set aside this type of, because we gave you an opportunity, you have not filed it. There must be something hanky-panky, that is why you have not brought it.
No, there is no hanky-panky.
Obviously, why on earth you could include all other minutes?
No, other minutes was included because the seniority was in question, my lord. His appointment and selection is not in question. His promotion to the post of process.
He has been granted the promotion on the ground that he is senior.
Yes, that minutes is there.
Now, my question is, this is to be adjudicated at a point of time when did you have the minimum thing done?
Yes,
The minimum benchmark, where
yes,
is the decision?
yes, that minutes
No,
is
no,
there.
that is okay, but where is the consideration? How much he got?
233, the how much he's got is there in the writ petition. His marks is there in the writ petition. He has an X.
Where?
No.
Obviously, that is not.
He has challenged the selection on the count that he was senior, not on the count that he got more marks in the post of process server, my lord. His seniority, that he scored more marks, that is there. আরে বুঝিছো, জানো মই। My lord, page 29 of the writ petition, the Hiranya Vallabh Bora, private respondent 5, he scored 99.2 marks. And his challenge is that there should have been separate, there are separate select lists, so separate seniority lists should have been there. He's not challenging to the post of process server that he got more marks or seniority come merit rule has been flouted.
Where is the minutes of the selection?
The benchmark fixing select.
No, minutes of the selection.
The post of process server. My
Ah.
lord, I'll produce that.
No, you can't.
My lord, he has not challenged.
No, that is the most pertinent thing.
I'll
That
produce
document
it. My lord,
means there is no document to that effect.
My lord, I'll produce it, my lord. The benchmark
Finally come to
fixing.
paragraph 13. 1-3.
Bharat Singh, yes.
দাও করে দিব।
My lord, it's fine, my lord. It's fine.
Read it.
As has already been noticed, although the point as the profiting by the state was pleaded in the writ petition before the High Court, as an abstract point of law, there was no reference to any material in support thereof, nor the point argued at the hearing of the writ petition. Before us also, no particulars and no facts have been given in the special writ petitions for the writ petition. My lord, this was not the ground on which he.
Read it.
But the point.
Don't jump into conclusion,
My lord,
Mr. Das.
I'm coming, my lord. Any affidavit, but the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the said application by so and so. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded and the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in counter affidavit, not only the facts, but also the evidence in proof of such facts have been pleaded and annexed to it. So the point that has been raised before us by the appellant is not entertainable, But in spite of that, we have entertained it to show that it is devoid of any merit.
So here, that affidavit is not, minus not there. So there is no selection. So if there is no selection, there cannot be an appointment of the respondent number 5. Matter
Minus is there, Miller. That is
We
never
don't
under
have-
question.
You have not enclosed.
Miller, that is
Sir,
never.
that is the most pertinent document.
Understand, Miller. Lordships wanted to
We-
see, Miller, I'll produce. But
Why,
that was
why should we allow?
no, that was never a question.
This type of case, there is the question. He says that he has not been provided any document. Isn't it your stand? Then it is
No,
very clear.
he never.
And therefore it was requirement of law, you should have brought in that.
But I'll brought in, Miller.
So
I'll-
we
I'll
allow
place
this
the-
repetition, I think division bench may go against you, but whatever may be.
Well, I'll
But
produce
for
I'll
my
produce-
sake, I think then the
Well,
High
for
Court
your
will
lord-
later on realize that to be more careful while drafting a counter affidavit and bring it before
Miller,
the
since
court.
it was never a question in the writ petition,
Then
Miller,
it
so
was
that's why.
drafted counter affidavit.
Miller, I'll produce the entire record for your
Not
lordship's
necessary.
satisfaction.
Why should I look into the
I'll,
records? It
Miller,
is
I'll,
not a
I'll produce
record.
the relevant minutes. only, Miller.
Thereby prejudicing the petitioner. Are you claiming privy
No,
are you claiming
Miller,
anything?
I'll give a copy to my learned brother also, Miller.
No, you can't. You
I'll
cannot.
give a copy to my learned brother.
It is the requirement. Everything. We are a court of record, so these records have to be there. It should have been brought in by way of an affidavit. It has not been brought in, so therefore that something must have done something.
Nothing
Isn't it
has
your
been done, my
categorical
lord.
statement
Lordship will
in your
kindly
petition?
see.
You see, he has filed an RTI also. Then also he has not been able to get it. Then you have not provided anything.
Page 233 is another minutes I have annexed.
Not on this premium. You have not produced anything.
So
There's no
far,
minute
how much
there.
marks they have got and what was the benchmark, that your lordship will find page 223. The following of the criteria seniority cum merit, my lord.
And this is on the basis of a draft gradation list.
And they give
an Ah.
explanation. They say that
And this was done after the recruitment process started.
no. Prior to that.
No, you say in your petition, kindly see. Page,
Yes.
page 14. No. Now you see page 14. Now going by the explanation above, it is evident that the impugned letter should prepare after the recruitment of the petitioner and EA is bad in law and so and
The
so.
original recruitment to the post of grade.
As such, on the basis of a impugned EA, the impugned promotion exercise carried out for the post of Iman is required to be. Now,
Page 14. That
show
was-
me the minutes of the meeting where you hold that he was number 2.
Lordship will kindly come to page 215. This was the minutes basing on which the seniority has been recasted, taking into consideration the merit.
Where? Page?
Page 215, my lord.
Read it.
Minutes of the meeting of the selection board held on 17/9/25. A meeting of the selection board is held today on so-and-so in the chamber of member so-and-so, so-and-so, so-and-so. The board has made threadbare discussion regarding the promotion appointment to the post of process server under the establishment of so-and-so resolution. After going through the all relevant documents, of all grade 4 employees such as appointment, joining report along with gradation list, it has come to notice of the selection board that the existing gradation list not prepared as per the marks obtained in the qualifying examination. We have also gone through the RTA reply of so and so, so and so, so
So
and
you
so.
prepare a gradation list without calling for objection. Is it permissible?
It was corrected, my lord.
No, you categorically say that it is not prepared.
No, prior to selection, it was prepared, corrected.
No. My question, your selection process have started with the advertisement.
Selection process was started with the advertisement.
So at that point of time, in 2000, minutes of the meeting held on 17/9/2025, you categorically say here that look here, the selection of the existing gradation is not prepared as per the marks obtained. Means there is no selection list prepared. The gradation list was not prepared till then, till 17/9.
There was one correct gradation this one. There was one correct gradation
Uh,
prepared.
it's okay.
Thereafter, it
No, they also say that it
That
was not
Milord-
prepared till then, 17/9. Thereupon, you make the gradation list without an
Please to-
opportunity.
Please to hold that seniority will, employees will be decided on the marks, basis of marks. My lord, in fact, in rule 2 of the, our ministerial service rule also, the fixing of seniority has to be on the basis of marks, apart from ABC, the initial portion of the 12. So seniority has to be fixed at the time of initial appointment, direct recruitment. Seniority has to be fixed on the basis of marks obtained in the select. That's a settled position of law. That was not
These
done.
people were there from 2013.
Yes.
From 2013, you have a select, everybody has a separate select gradation list. You were there in motorway somewhere, MSCT.
No, there
Somebody
was,
was somewhere, all these things.
no,
that
there,
establishment itself, they had a separate gradation list for grade 4, and I have annexed it.
Where is that?
there was a,
Annexure 10, page 34.
834.
Starts at 34 and 36, the grade 4.
34. 30?
this was 2024.
This was in 2004.
2024.
24.
He has
So,
challenged this gradation list,
which one?
petitioner.
This has not been challenged. You're
Challenge.
challenging this.
Challenge.
I'll withdraw that prayer, madam.
Uh,
I'll
He's
withdraw that prayer.
withdrawing it. He's withdrawn it. Where is your name, Mr. Counsel? What is your name?
Page 36.
Jitu Bora. Where is he?
Page 36.
333.
Gradation list of grade 4 staff of the year 2024.
He is number one. And what is the respondent? He is number four. 4. So,
it was wrong. That's why it was corrected.
understood. Why did you correct it without notice to anybody? Can you do it? One fine morning, oh, we find that gradation list which is there, published,
No,
whatever
no,
may be, we
If
don't
there-
follow it.
if there- take a
Then
practice-
everybody can change at any point of time, maybe, and this will only lead to unnecessary litigations. So therefore, the consideration of the minutes, how they considered it, the gradation list, is very relevant. And that document is not here.
No, that explanation in the minutes, my lord, affidavit I have just read.
No. There you say
They
that
say
we
that
are
there was
going to
mistake.
prepare a gradation list. Okay. Now, how the gradation list was prepared? How did you consider?
Therefore, the present gradation list ought to have been modified as per marks obtained in the qualifying examination.
Mr. Counsel, I
I'm sorry.
understand.
I'm sorry.
My question is, how did you consider it? The consideration of the gradation list was done in the final minutes. After taking into account who got the minimum marks.
No,
Minimum benchmark, obviously.
no. What I have understood, my lord. My lord, there were 3-4 resolutions. One of the resolution is this 215. They have taken decision in this resolution with regard to the seniority position. Accordingly, that page 217 seniority list has been published, my lord. This is not under challenge before your lordships, my lord, in the writ petition. And after that, my lord, there is another resolution.
Challenge. He doesn't know anything. You even hide the minutes also, the final minutes also.
Hiding, my lord.
Obviously,
Since there-
what stopped you from enclosing the final minutes?
I'll
Unless
produce,
you
my lord.
giving
I'm so
privilege.
sorry. But I am so sorry, my lord. I'll produce.
I
the-
remember that judgment of, what is that? A.K. Karla or something. 1994 for SSC. That judgment says if you are claiming privilege, you have to claim it on the basis of that. Are you?
No, no, my lord.
Then not enclosing is
I'll
that the
plead-
minutes have not been enclosed, and in view of this judgment, we set aside.
But the
Ask
main,
them to do a fresh exercise.
the main minus, my lord, I'll place it
No,
before
you
your
have-
lordship's, my lord.
I didn't see.
At page 206. At page 206, the explanation why they did not do it.
Where is the acceptance of the final minutes? The gradation list?
My lord, it
No,
will be,
because,
it will be in the
but,
next, my
but,
lord.
but,
I understand, my lord.
but Mr. Das, I
understand,
tell
my
you,
I understand.
the course of action which you have taken
Yes,
after the initiating the recruitment process, then saying that, look here, the gradation lists have not been prepared properly. We prepared a gradation list properly, and accordingly you prepared, and more particularly taking into account that it is a seniority come merit, and then you appoint somebody. Isn't it the basic violation of natural justice to him? Isn't it, Mr.
It is my TJ case. It is my
My
TJ
lord,
case.
my lord,
Changing the rule of the game, man. How can they change the game?
no, where is the changing of the rule of the game? There is no changing of the rule of the game, my lord.
Yes, you at that point of time when you initiated the process,
Yes.
there was a different gradation list.
My lord, it was a simple case wherein, my lord, there was a wrong, that wrong was sought to be corrected by this minutes, my lord.
Without information to anybody.
Lord,
Just imagine a case. I'm telling you. Okay, this is
earlier-
this is a
earlier-
different case. Let's go into the case of bigger cases like superintending engineers and all, where the most basic thing is on the question of seniority is being
understand
looked out
that.
there. No, wait. One fine morning, you say that, okay, at the time of selection process is going on, oh, we need to correct the gradation list. Then the gradation list is corrected. No information to anybody, except the 4 or 5 members of the committee know. And thereupon, you select it on the basis of seniority come merit and give it to him because this is it. Isn't it the basic requirement that when you are preparing a gradation list, that information has to be given to the person concerned who will be affected? And that too, where there exists a gradation list in 2024. I think this is a good case, Mr. Bhardwaj, although your pleadings are inapt.
Lord, in my affidavit, my lord, there is an
Affidavit, you
explanation.
have not enclosed the main part.
No, no, I understand, my lord, that I'll produce. My lord,
Chalo,
our stand
don't
is
have a
very
CAB.
clear.
I will pass that order here only.
My lord, para 9,
I allow your writ petition then.
my lord, I'll produce the
No.
resolution, my lord.
Absolutely no, because no, on the basic aspect that you have carried out a selection without first ascertaining or giving an opportunity to the persons as regards the gradation.
Para,
This is the very, the moment Mr. Bhardwaj is making a very categorical submission that how could you have changed the at the time of carrying on or proceeding with the selection, that too without my information. I have to answer that. The moment I answer, it is not necessary. It will apply for everybody. We are a court of
I
records.
understand, my lord.
So therefore, how do you help it?
para 8 and 9 of my affidavit,
No,
my
no,
lord.
your
I have,
affidavit does bereft of that minutes.
my lord, that minute is not there, but so far as seniority
Did
list
you
is,
consider the gradation list? Yes, a gradation list was prepared on 17/9/2025. And thereupon you do it. And this is not a simple gradation list.
draft
You are
gradation-
looking into this mark, he got this secured, he has. This is a contentious issue. It is not a simple issue of a gradation list where everything is already settled. From there, they pick it out and make it. But you are correcting a gradation list. This is a very
Our-
serious
my lord,
offense.
sir, correction is not wrong, my lord. It's not divorce the rules.
This, bro.
Our correction is not divorce
Show
the
me
rules.
that you can correct a gradation list at a during the
No, let the
selection without information.
Let the petitioner show before this honorable court, he has got
It
a
is
right
true.
to.
You have done it. You therefore show me that whether it is permissible to correct the gradation list without due information to the people who are
My lord,
affected.
Para 9 of the affidavit, we have said that after pursuant to this, my lord, we have shown the affidavit, sorry, my lord, the gradation list to everyone. Para 9 of the affidavit, my lord. That is the stand of the
Showed
respondent.
to everyone. I hope the shown means you call them. This is the gradation list we have prepared.
Perhaps, my lord.
Is this the way? Isn't it the requirement of a notice?
My lord, my lord,
There
Is
is no,
it a requirement of a notice? That, okay, we are putting a notification, this is the final gradation list.
I understand his contention, but the thing is that
I not
Publishing
only
of-
understand his contention, I fully appreciate his contention.
Milord, publishing of draft gradation list, Milord, it's not a matter of right. Because I understand.
Changing in the gradation list at a later point is is a question where his rights is being affected, is a question he has a right to know, is a matter of right.
Wrong has been corrected.
And obviously he could have put an objection, no, this is that, and you could have corrected it or may not correct it. But that was not done. You uniformly think that, oh, we know everything. Who are they? They are peons. What else they will say?
That not initial
Isn't it,
2024.
Mr. Samaria? Is this how our district judiciary is functioning? You are always unhappy.
That's my sentiment.
2024 seniority list was wrong. That was corrected. That's the thing. Milord.
You could not have corrected. Anyways, let me pose a question to you by this particular thing so that it maintains came in on record. First up, heard Mr. P. Bhardwaj, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Sharma, the H.K. Das, the learned senior counsel, assisted by so-and-so, appears on behalf of the Gauhati High Court. The petitioner have challenged the appointment of the respondent number 5 to the post of process server, which is selected on the basis of the criteria seniority cum merit. It is the specific case of the petitioner that the petitioner, in the gradation list which was prepared in the year 2024, the petitioner was at serial number 1, whereas the respondent number 5 was at serial number 4. The petitioner further contends in the writ petition that the selection process was initiated for the promotion to the post of process server. In the midst of the said selection process, the selection committee changed the gradation list without due information to the petitioner. The gradation list, without even calling for any objections. On account of the unilateral actions on the part of the selection committee to change the gradation list, the respondent number 5 was brought to serial number 1 and the petitioner was brought to the serial number 2 in the seniority. The consequence thereupon was that the respondent number 5, on account of the seniority merit, was appointed to the post of process server. This court have also heard Mr. H.K. Das and have also the learned senior counsel and have also perused the materials on record. From the perusal of the materials on record, it is apparent that on 17/9, apparent that in the year 2024, there was a gradation list prepared wherein the petitioner was at serial number 1, whereas the respondent number 5 was at serial number 4. However, in the meeting which was held on 17/9/2025 for the purpose of selection to the post of the process server, the selection committee in its minutes decided to freshly prepare a gradation list. And in terms thereof, the gradation list was prepared on 17/9/2025, as would be evident from the subsequent minutes of the meeting which was held on 14/11/2025. This court inquired with Mr. HK Das, the learned senior counsel, as to whether any notification was issued calling for objections while preparing the gradation list on the same day on which the decision was taken in the minutes of the meeting dated 17/9/2025. The learned senior counsel referred to the paragraph number 9 of the affidavit in opposition, wherein it is stated, wherein the learned senior counsel claims that the respondent, the petitioner, as well as the others who are there, were shown the gradation list. A question arises as to whether such a course of action is permissible without even putting to notice the persons who are going to be affected by the change in the gradation list, so that a chance of submitting an objection arises. Given. It is also very relevant to take note of that in the affidavit in opposition, which was filed by the respondent numbers 1 to 4, the minutes of the meeting by which the selection was carried out, which would otherwise would have shown as to how the gradation list was taken into consideration, have not been enclosed. In this regard, this court finds it relevant to observe that the Supreme Court, in the case of Bharat Singh versus so-and-so, reported in 1988, 4 SCC 534, more particularly at paragraph number 13, had categorically observed as to what should be the contents of a counter affidavit, taking into account that the minutes of the meeting on the basis of which the selection was carried out is a document which ought to have been brought on record unless the privilege is being claimed. And the said document having not been brought on record, a question arises, should this court entertain that there was a due selection carried out without the said document? These questions this court will further hear both the counsels on the next date.
I'll bring the.
No further liberty is granted to the respondents to bring on record any further documents.
I'll place the. I'll
You
place.
file an I. File I. Then only things will happen, not by
Fine,
this manner.
Fine, fine,
That is
fine.
your, I will write. You file an I seeking leave, then only things will.
fine, my lord.
Date. We'll have it next Tuesday.
My lord, can be 27, my lord.
No, Tuesday. Then you don't get the chance even to file the I.
My lord, 27. 27.
In the matter on 27. Okay.
Deeply obliged.
Mr. Gogoi, I'm taking up your matter next. Just wait. First, I'll take his matter. Then I'll take your. Yes, Mr. Gogoi.
This is the matter. And the subsequent notification, letter communication dated, my lord, 15/7/2026, the L1 bit of the petitioner was rejected, my lord. Lordship will find that part in the second page, serial number 4.
L1. Yes.
Technical bit cancellation.
Because-
Serial number 4 and 6, man. Tinsukia, serial number 6.
6 is what? Is
Uh,
L2.
No, he was L2, but the L1 was,
Yes.
his technical bit was cancelled, my lord.
That lordship will find in serial number 6, para 6.
Now, my specific question was twofold. The question was as to whether it was based on 26.
Yes, ma'am.
If it is on 26, 26 does not remain, so then consequentially 15(7) does.
Yes, it came in, my lord. For votes.
That is one. Second is as regards the, you have challenged the rejection, the cancellation of your bids.
5/8/2026 under challenge.
You have challenged the minutes?
Yes, ma'am.
The 4/8.
4/8, page 21.
4/8 you have challenged it. Now, tell me one thing, Mr. Deka, whether you have submitted a representation prior to that, that 28/2026 have been set aside.
My lord, after passing of the judgment, my lord, we have communicated the.
After is later, I'm saying on 4/8,
Yes, ma'am.
as on 4/8.
Page 63 and 64, ma'am.
Page
63 and 64. 63 is the communication of judgment of the court order regarding. It was dated 3/8/2026. Down below, lordship will find the date. And the next page, the acknowledgements are done.
They have applied for the certified copy.
Yes,
That they have
and-
mentioned, ma'am.
Yes,
On
my lord. And
3/8.
on 5th, my lord, we have communicated the.
Huh?
certified copy. On 3rd, my lord, we have informed about the passing of the judgment by this honorable court, page 63. And page 65, after obtaining the certified copy, we have communicated to them, my lord, page 65.
And the
66.
other question. We're enclosing what?
Page 66, my lord.
Page 64 is what? Email?
64 is the, my lord, this is the email, my lord. And the hard copy is this, the acknowledgement is there, my lord, the authorities to whom we have marked the copy.
That copy is at page 66.
63, the list is there, my lord. Chief engineer EAP was there at serial number 12.
Hmm?
Page 63.
Hmm.
Serial number 12, chief engineer PWRD EAP. We have also informed him about the passing of the order dated 3/8/2026. And thereafter, that his acknowledgement is also there, my lord.
Now, under such circumstances, this minutes on this reason cannot be there. We need to interfere with. You may reconsider in terms with the public procurement. If there is single bidder, what is there, that is your.
Yes, sir.
You may look into it. So, but as regards this, we interfere only to that effect. That this could not have been the reason in view of the information provided.
There will be no direction that it should be allotted to the petition.
Huh?
There will be no direction from the honorable.
No. I'm asking you to again
I understand.
reconsider them, taking into account that 15.7 is no longer there. And thereupon to take a call on whatever you feel like, because there is some public procurement
Yes.
rules which categorically say
24.
that when there is a single bidder,
Yes.
I think 20,
It is
rule 20,
no, rule 20.
20, 25?
Yes, madam, 20. Rule 24, sub rule 20.
Ah.
Sub rule 20, sub clause 1, 2, and 3, madam. The
That is
reasoning
your
and all,
prerogative.
with the approval of the
You may
government.
look into that because this is a single bidder.
Madam,
But the reason, because if you had said the other reason, then I would not have interfered.
I understand, madam.
But without the, only for this reason, I have to interfere.
Lots of.
And more particularly when you were there in that court, huh?
Lots of.
Would not be proper. Heard Mr. R.M. Das, the learned counsel, R.M. Dekar, the learned counsel appearing on behalf of the petitioner. So therefore, the natural consequence is that the other tenders in respect to this work has also to be.
No, except this decision for these two packages, madam.
Only these two packages.
Tinsukia and Golaghat.
So these two, you have to then
Revisit, madam.
reconsider in view of this direction.
Madam.
What is the last date for submission of the bid in the next?
In the
Huh?
9th of September. 9th.
Okay, so before that also you can consider,
Yes, madam.
if you consider that on the basis of 2024,
Lots of.
you may go ahead, that is your lookout. So
Lots of.
we need not interfere with the
New one.
area, but I'll say that you need to consider this before
It will
proceeding.
be
with
subject to
this.
outcome, my lord, of the minutes, my lord, new fresh minutes. The new tender will be subject to.
So and so appearing on behalf of the petitioner, Mr. So and so, learned additional advocate general appears on behalf of the respondent numbers 1 to 7.
Yes.
The present petition has been filed by the petitioner, assailing the communication dated 15/7/2026 issued by the Deputy Secretary of Works to the Government of Assam Public Works Department, conveying the Chief Engineer PWD, Roads Assam, the approval of the government in debarring the petitioner from participating in any ongoing or future tenders under the Public Works Road Department for a period of 1 year with effect from the date of issuance of the order dated 26/2026 from, is it 26 or from the date of issuance of the letter?
20/06/2026.
Where's that impugn letter? From the date of issuance of the order dated 26/2026 from the
53,
office of the Chief Engineer PWD bracket NH Works Assam. The petitioner have also assailed the decision of the tender committee meeting dated 5/8/2026, wherein it was decided to cancel the L1 bid of the petitioner in respect to two works, a L1 bid of the petitioner in respect to two works on the basis of the communication dated 15/7/2026. The brief facts of the instant case. The petitioner herein is a company registered under the provisions of the Companies Act 1956. The petitioner claims to be a government registered civil contractor under various departments of the state government, including the Public Works department bracket NH works department, public works department bracket NH works, public road department, public works road department, and on various departments of the state government, including the various divisions
Branches
of the
public works
various branches of the public works department. Where the 26 order? On 26/2026, the chief engineer, PWD bracket NH Works, Assam, asked an order thereby debarring the petitioner from participating in any ongoing or future tenders under the department, under the PWD bracket NH Works department for a period of 1 year from the date of issuance of the said order. The petitioner, being aggrieved, filed a writ petition challenging the said order dated 26/2026, issued by the Chief Engineer, PWD NH Works. The said writ petition was registered and numbered as WPC number 3398/2026. It is further relevant to take note of that during the pendency of the said writ petition, the Deputy Secretary Works to the Government of Assam, Public Works Road Department, also issued a communication to the Chief Engineer, Public Works, PWD Roads Assam, informing inter alia to the later that in view of the communication dated 26/2026, the petitioner company have been debarred from participating in any ongoing or future tenders under the Public Works Roads Department, Assam, for a period of 1 year from the date of issuance of the order dated 26/2026. It is also relevant to take note of that the Chief Engineer, PWD NH Works, also issued an office order on 1/8/2026, whereby the registration of the petitioner bearing registration number REG-CON/PWD NH 2024/3890362 was suspended on the ground of unsatisfactory works. The writ petition, being WPC number 3398/2026, was taken up for consideration on 3/8/2026. In the said writ petition, an additional affidavit was filed by the petitioner, whereby the communication dated 1/8/2026 was also brought on record. The learned coordinate bench of this court, by the judgment and order dated 3/8/2026, set aside the order dated 26/2026, as well as the office order dated 1/8/2026, both issued by the Chief Engineer, PWD, and its works. Full stop. Paragraph number 7. Eight, 9 and 10 being relevant are reproduced hereinunder. It is further relevant to take note of that the said judgment on order was pronounced in open court in presence of the learned additional Advocate General of Assam. Immediately upon pronouncement of the said judgment, the petitioner issued a communication to the various officials of the PWD in the issued communications to various officials in the different branches of the PWD, including the Chief Engineer, PWD Roads, Assam, by the communication dated 3/8/2026, stating inter alia that the evaluation of the bids so submitted by the petitioner in connection with another tender
It's 27.
bearing tender ID number 2026 underscore PWD underscore 51052 underscore 17 be taken up on a subsequent date.
Another tender on page 39. There are two tenders. Page 39.
And tender ID number 2026 underscore PWD dash 51052 underscore 10 be taken up subsequently. So that the certified copy of the judgment and order dated 3/8/2026 passed in WPC number so and so can be produced. It is also seen that on the very date, that is on 3/8/2026, the soft copy of the judgment and order dated 3/8/2026 was emailed to various authorities, including the Chief Engineer, PWD, there. Which email?
My lord,
Soft
on
copy has not
38,
been
my
provided.
lord, we have informed them that order has been passed.
And
And
certified
as
copy
well as we
applied.
got the certified copy, we will communicate to you.
Email,
Page 63, my lord.
Page
Email is at,
64.
my lord, page 64.
page 64.
Yes, sir. Page 64 is on August 3rd, my lord. On that
Same date.
Same date.
Where's the email? Which is the email address?
My lord, that the chief engineer NH work.
We are not concerned with NH work. We are concerned with PWD.
These are all NH.
My lord, what my lord, we have by hard copy at page 63, we have communicated this to the road authorities. My lord.
Where is the seal? We have sent by ECS, means speed post.
The receipt is here, my lord, at page
Where is the
63.
receipt?
This on page 63, my lord. The consignment statement.
Where is the receipt?
My lord.
Huh?
At page 64, there is a seal, my lord.
Where? Ha.
This one.
An email. In addition to that, it is also seen, email to ineligible. In addition to that, it is also seen from a perusal of page 64. The service of the certified copy of the order dated judgment and order dated 3/8/2026 in WPC number so and so was effected upon the chief engineer PWD roads on 4/8/2026.
My certificate copy has not been furnished on 4/8.
It
was furnished on 5/8. We obtained a certificate copy on 5th, my
Now,
lord.
what is the seal for?
My lord, we have communicated them that this order has been passed.
In addition to that, it was, in addition, the said communication dated 3/8/2026
Yes.
was communicated to to the chief engineer public day dated so and so on 4/8/2026, as would be apparent from a perusal of the seal at page 64 of the writ petition. Subsequent thereto, on 5/8/2026, the certified copy of the judgment and order dated 3/8/2026, passed in so and so, was served upon the various authorities of the different departments of various authorities of the PWD departments, PWD, including the chief engineer PWD roads. It is the further case of the petitioner that on 5/8/2026, the petitioner came to learn that the petitioner's bid submitted in respect to two contractual works wherein the petitioner was the sole technically competent and lowest bidder were rejected on account of the communication dated 15/7/2026. So it is under such circumstances the petitioner has approached this court by filing the present writ petition. The learned counsel, because he was the sole, one is sole and the other there were two. One was technically not competent. So therefore I use the word technically competent sole. Lowest bidder. The present writ petition was filed on 6/8/2026. When the matter was listed before this court on 10/8/2026, this court issued notice and sought for instructions from the PWD department on two aspects. First, as to whether the order dated 15/7/2026 was solely dependent upon the order dated 26/2026 issued by the communication dated 15/7/2026 was consequential to the order dated 26/2026 issued by the Chief Engineer PWD NH Works. And secondly, as to whether the PWD the impugned communication dated 15/7/2026 was preceded by any show cause notice. Mr. It is relevant to take note of that there are two additional affidavits which was filed by the petitioner on
Both are on 10.
10/8/2026, bringing to the notice of this court that in respect to the works wherein the petitioner's bids were cancelled, fresh tender notices have been issued. Today, when the matter has been taken up for final disposal, Mr. B. Gogoi, the learned Additional Advocate General, submitted that a communication dated 15/7/2026 impugned in the instant proceedings is consequential to the order dated 26/2026. Further to that, during the course of the hearing, the learned Additional Advocate General have also produced the minutes of the tender committee meeting for the combined evaluation of the road safety improvement works on SH and MDR under ASRIP. The said minutes is kept on record and marked with the letter X. From a perusal of the said minutes, it is apparent that in respect to the package ASRIP/A/RS-3 in the district of Golaghat, and in respect to the package ASRIP/A/RS-6 in the district of Tinsukia, though the petitioner was the sole technically competent and lowest bidder, the said bids were rejected solely on the ground of the communication dated 15/7/2026. Next. In the backdrop of the aforementioned facts, this court heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. From a perusal of the materials on record, it is apparent that the impugned communication dated 15/7/2026 was issued on account of the order passed on 26/2026 by the Chief Engineer NH Works, whereby the petitioner was debarred for a period of 1 year from the date of issuance of the said order. This aspect was also informed to this court by the learned Additional Advocate General Assam during the course of the hearing. Full stop. It is the opinion of this court that if the order dated 26/2026 cannot remain, had already been set aside, the consequential communication dated 15/7/2026 cannot also be allowed to, cannot also be sustained. Full stop. This court also finds it relevant to take note of the minutes of the meeting held on 4/8/2026, whereby the package numbers ASRIP/A/RS-3 in the district of Golaghat and ASRIP/A/RS-6 in the district of Tinsukia, wherein the petitioner was the sole technically and competent bidder, technically competent and lowest bidder, was rejected solely on the basis of the communication dated 15/7/2026. This was done so in spite of having due knowledge that the said communication dated, the order dated 26/2026 was set aside by this court or by the judgment and order dated 3/8/2026 passed in WPC number so and so. Under such circumstances, the rejection of the petitioner bid in respect to package number so and so and so and so, so and so in the district of so and so, so and so in the district of so and so, solely on the ground of the communication, the impugned communication dated 15/7/2026 cannot be sustained in law. Next. This court also takes note of the additional affidavits which were filed by the petitioner, whereby tender notices have been issued in respect to the works wherein the petitioner's bids have been rejected by the minutes of the meeting held on 4/8/2026. First, it is relevant to take note of that the last date for submission of the bids is on 9th of
7 September.
is on 7th of September 2026. First, taking into account the above, the present writ petition therefore stands disposed of with the following observations and directions. Number one, the impugned communication dated 15/7/2026 issued by the Deputy Secretary to the Government of Assam, PWRD, stands set aside and quashed. Number two, the impugned, the minutes of the meeting, the rejection of the petitioner's bid in respect to package number so and so in the district of so and so and package number so and so in the district of so and so, as recorded in the minutes of the meeting held on minutes of the tender committee held on 4/8/2026, solely on the basis of the impugned communication dated 15/7/2026 cannot be sustained in law. Accordingly, the minutes of the tender committee meeting insofar as the decision in respect to package number so-and-so in the district of so-and-so and package number so-and-so in the district of so-and-so is set aside and quashed. Next. This court is further opinion and accordingly directs the respondent authorities and more particularly the tender committee to reconsider the case of the petitioner in respect to the package number so-and-so of Gulaghat in the district of so-and-so package number so-and-so in the district of so-and-so without reconsider the case of the petition, the bids so submitted by the petitioner in respect to package number so-and-so of the in the district of so-and-so and package number so-and-so in the district of so-and-so afresh without taking into consideration the impugned communication dated 15/7/2026. How much time will take? 7 days.
Yes, it can be.
I'll record that. No, then I am not there for set aside. The learned counsels, the learned additional advocate general submitted that the said exercise would be carried out within a period of 7 days from today. Next. In view of the said category, in view of the categorical submission made by the learned the additional advocate general that the said exercise of reconsideration of the petitioner's bid in respect to package number so-and-so, bids in respect to package number so-and-so in the district of so-and-so and in the package number so-and-so would be reconsidered within a period of 7 days from today. This court is not inclined to interfere with the fresh tender notices which have been issued enclosed in the additional affidavits. It is, however, observed in the circumstance, it is the opinion of the tender committee to grant the contracts in respect to package number so-and-so in the district of so-and-so and the package number so-and-so in the district of so-and-so to the petitioner, comma. The issuance of the tender notice insofar as the package number so-and-so and so-and-so which are the subject matter of the tenders issued in the affidavits shall not be further proceeded with. It is clarified that this court have not interfered with the minutes of the tender committee dated 4/8/2026 in respect to the other packages which is not the wherein the petitioner is not involved. It is further clarified that this court have not passed any directions in respect to the other packages which are the subject matters of the tenders which have been tender dated so and so. What is the dated?
You tendered, but page 253, it was uploaded on 8th of August 2026.
No. This is request for small works.
Yes, page 253, it was uploaded on 8/8/2026.
This is only one work. There is no other works. Or is it other works?
No, there are two works. It is for two works, madam.
No, understood. It is only for these two works.
Yes, ma'am.
Only these two, madam.
So there is no other works in these tenders.
No, here, my lord, total it was, my lord, 6.
Not in days. In the additional tenders.
Yes,
days.
yes. Yeah,
Only-
only two,
only
only
two
these
numbers.
two.
So therefore, we can verify, it is further clarified that it is clarified that the tender, that based upon the consideration of the respondents, the tender committee based upon the decision upon the consideration of the bids of the petitioner in package number so and so and so and so and so, the tender committee shall proceed with, shall consider as regards the necessity to proceed with the notice inviting tenders which have been issued, the request for bid small works which are enclosed to the affidavits.
May I pay for this minor, copy of this file?
Take it. Take a photocopy.
Yes, I'll take a photo.
The registry shall provide, the quartermaster shall provide a photocopy of the minutes which is kept on record and marked with the letter X to the petitioner. I'll just put it properly, that thing, meaning thereby that once they tender, once they consider, if they think that it is not necessary, then it will be. And if they think it is necessary, that they, on account of Assam procurement rules or whatever may be, they say that single tender we may not, then they may proceed. And I'll say that the decision, the decision which is to be taken shall be communicated to the petitioner immediately thereafter.
Yes, and my lord, if it goes against us, my lord, then we can.
You at liberty. Wait, let me take his case first. You wait for some. Yes.
Get your lordship, but I had conveyed to Mr. Rahul.
Huh?
Counsel appearing for respondent number 6.
What?
Counsel appearing for respondent number 6. But I had requested him to appear. He said he has left.
So this matter is fixed on 21st. On that day, it may be taken up, and already the stay order has been vacated, Lordship. It may not be restored.
I've not signed it.
But
So
Lordship,
don't come up with that excuse.
Lordship, but in their presence, Lordship, respondents.
Hardly matters.
Lordship.
For me, those things hardly matter. Their presence.
But there is an urgency, Lordship, in this matter. Since
Therefore, argue, forget about him. I may dismiss his case without him. If we have a good case.
on Tuesday, Lordship, in that case, and on Tuesday, it may be taken up for final disposal, Lordship.
Then I have to, you argue, you want to argue, otherwise if you don't want to argue, we'll have it on Tuesday then. In time order, we'll extend it till then.
Lordship.
No heavens will fall. Tuesday, am I busy? Tuesday, I fixed some matters, huh? Thursday. Not Tuesday.
If tender process is delayed, Lordship, it may cause inconvenience, Lordship, because it is laundry service and railway may suffer, Lordship.
Huh?
Lordship, if delay is caused, Lordship, it may cause some inconvenience, Lordship, to the railway.
Okay, Tuesday. And Mr. Dubey, I know you are a very busy counsel, but you have to be very careful with this court. Yesterday, day before yesterday also, we had the same affair.
I was in court number 6.
Hardly matters to me, wherever you are. But for me, if you don't are there, I can't help you with that. Okay, next Tuesday, interim orders passed earlier shall continue. Liberty given to the petitioners to mention, to the parties to mention the matter for upgrading. Yes, Mr. Sharma, where are you? Yes, on which point I wanted to interfere on the last date?
Last one. Impugned, my lord, my lord, page 120.
Hearing the appellate authority.
My lord. Page 125, my lord.
Page 120.
There is no reason, my lord.
There's no reasons. I had passed one judgment that, you see, the appellate authority is required to assign reasons why it is required in difference. Flex mark. Flag. I appeals. Food Distribution and Consumer Affairs Department. Who will decide?
Yes, my lord. The next flag, my lord. I have marked.
So whom should we direct?
My lord, secretary, my lord.
To the secretary. Where is it mentioned?
The next black mark, my lord.
Secretary. Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. M. Setia, the learned counsel, who appears on behalf of the respondent numbers, all the respondents. All the respondents.
Yes, ma'am.
The present petition has been filed by the petitioner, being aggrieved by the order dated 15/9/2021, issued by the Commissioner, Lower Assam Division, as well as the order dated 21/5/2020, issued by the Deputy Director, Food and Civil Supplies and Consumer Affairs, Kamrup Metropolitan District, whereby the petitioner's Fair Price Shop license was cancelled, isn't it? The brief facts which led to the filing of the present petition are that the petitioner herein was a license holder of a Fair Price shop of Panbari Chandrapur Circle under Pragjyotishpur Police Station in the district of Kamrup Metro, Assam. The license was issued by the Deputy Director of Food, Civil Supplies and Consumer Affairs, Kamrup Metro, Assam. That is the respondent number 5. On 30/7/2019, the additional Deputy Commissioner, Kamrup Metro, that is the respondent number 4, respondent number 6, had issued a order thereby suspending the petitioner's license in terms with clause 15(1) in clause 15 of the Assam Public Distribution of Articles Order 1982, for short, the Order of 1982. The said suspension was made on the basis of a report submitted by the Superintendent, Food, Civil Supplies and Consumer Affairs, Kamrup Metro, that is the respondent number 7. The petitioner was issued a show cause notice and thereupon the petitioner replied stating inter alia that the charges leveled against the petitioner had were fictitious and had no basis.
Be that as it may, by an order dated 21/5/2020, the respondent number 5 passed an order thereby cancelling the petitioner's license was the petitioner thereupon preferred an appeal before the Commissioner of Lower Assam Division, Gauhati, in terms with what is the appellate order? Appeal is made under
Clause 29C. Clause 29C.
Clause 29C. Clause 29C, small c, of the Order of 1982, raising various issues, raising various grounds, challenging the order dated 21/5/2020 passed by the Deputy Commissioner, the respondent number 5. It is the allegation of the petitioner that no opportunity of hearing was granted, and on 15th of September 2020, the respondent number 4, party, the respondent number 9 had dismissed the appeal. Being aggrieved, the petitioner therefore approached this court by filing the present petition. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submitted that the issuance of the notice was by the respondent number, the notice was issued. The show cause notice was issued by the respondent number 6, isn't it? Additional Deputy Commissioner, who was not the licensing authority. Was there any hearing? No.
Before my cancellation?
Before initial cancellation?
No, but they stated that they have made an inquiry. That's
It's
why,
okay.
but no,
Inquiry report submitted to you, given to you?
no, my lord, they replied, my lord, I have got.
The petitioner thereupon submitted a reply to the respondent number 6. An inquiry was conducted behind the back of the petitioner by the respondent number 7. And even without providing a copy to the petitioner, the order was passed on 21/5/2020 against the petitioner. 21/5.
Yes, 21/5/2020 cancellation.
2020.
Yes.
What, this had something to do with COVID? The allegations? Because this was the peak COVID. Nobody was allowed to move anywhere. Something to do with COVID.
Sorry.
The smile in Mr. Ashrama's face shows. On 21th here. No copy of the affidavit of the report was submitted to the petitioner. Thereupon, the order was passed by the respondent number 5. That too without providing the petitioner an adequate opportunity of hearing. The learned counsel further submitted that, taking into account that there is an appellate remedy, the petitioner approached under clause 29C of the Order of 1982, and in a most perfunctory manner, the respondent number 9 dismissed the appeal. The learned counsel submitted
that the manner in which the adjudication was carried out can be writ large on the face of the impugned order dated 15th of September 2021. 15th of September 21 or 20?
21.
Down below is 20 up on top.
In the middle portion also some order as 7/7/21 it is written. After order.
The order, writ large. Inasmuch as there is no reasons assigned in the impugned order,
15 September 2020.
Mr. MCT, the learned counsel appearing on behalf of the respondents, however, submitted that the petitioner was granted adequate opportunity by the licensing authority as well as the petitioner, the licensing authority. In addition to that, the report which was submitted by the respondent number 7 categorically showed that the petitioner had grossly violated the provisions of the order of 1982, terms of the license, as well as the provisions of the Essential Commodities Act 1955. He therefore submitted that this is not a fit case wherein this court may exercise the powers under Article 226. Anything more? This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Upon perusal of the materials on record, and more particularly, a perusal of the order dated 15/9/2021, it is seen that though, and more particularly a conjoint reading of the memo of appeal so filed by the petitioner and the order dated 15/9/2021 impugned in the instant proceedings would show that there is no reasons which have been assigned by the appellate authority. It's a trite principle of law that when a statutory appeal is being provided, it is also the mandate of the appellate authority who acts as a quasi-judicial authority to pass a reasoned order. An order passed bereft of reasons renders the said order in violation of Article 14 of the Constitution. Taking into account the above, it is the opinion of this court that a direction should be passed upon the appellate authority to reconsider the appeal of the petitioner by passing a reasoned order. This court also takes note of that the Commissionerate Lower Assam Division, Gauhati, stands abolished. And in terms with the notification dated 16/11/2023, the appeals filed under clause 28A, 29. Huh? This is only there is demand 28A. Appeals filed under the order of 1982 had been transferred to the Food, Public Distribution and Consumer Affairs Department. It is further seen from another notification dated 20/11/2023, whereby the jurisdiction to decide appeals have been entrusted upon the Secretary, Food, Public Distribution and Consumer Affairs Department, or any other authority which the department considers deemed fit made the appellate authority in place of the divisional commissioner. So taking into account the above, the incident with petition therefore stands disposed of with the following observations and directions. The impugned order dated 15/9/2021 whereby the petitioner's appeal so filed against the order dated, what is the order date?
21/5/2020.
21/5/2020 is set aside and quashed. The secretary, food, the naam to ase lamba to food supplies public distribution, is directed to again hear the appeal so filed by the petitioner afresh and then is again directed to decide the said appeal afresh by giving the petitioner an opportunity of hearing. This court further observes opportunity of personal hearing. Personal hearing,
Personal hearing of my lord, represented by the my lord counsel also.
represented or personal hearing, a personal hearing or give a personal hearing. Mr. Ashram, the learned counsel appearing on behalf of the petitioner submits that for the last 6 years, the petitioner's fair price license have been cancelled. And therefore, a direction be issued that the said appeal be disposed of as early as possible, be disposed of expeditiously. This court have also given an anxious consideration to the said aspect, and it is the opinion of this court that there is a requirement of the culmination there is a requirement of an early resolution of the dispute in the interest of not only the petitioner but also the state. Accordingly, this court directs the secretary, to dispose of the appeal within a period of preferably within a period of 6 months from the date a certified copy of this judgment is served upon the respondent number, upon the commission secretary service. I give this. Itu amak lagi ubisok.
While the member MSCP Gauhati on 12th December 2025 forwarded the representation for regulation, page 70, my lord, without waiting the outcome of the Registrar General, my lord, all of a sudden adopted the decision for termination, the prayer of the regulation, page 83, my lord. And it shows that no proper consideration is given effect. Page 70. Affidavit 5 of the responsible party.
So the post has been filled up.
My lord, the post has been filled up by way of advertisement, but my lord, in my information, my lord, the still posts are there, my lord. Still posts are there, my lord. My lord, page 70 and 80. Can you see? Page 70, lord, just look for a moment. My lord, there is a representation on the basis of the direction passed by the Sonal Court just submitted, and it was forwarded for necessary consideration to the
Page
70 of the affidavit filed by the respondent number 5.
I asked something last time, Mr. Busho.
Yes, ma'am.
Yes, Mr. Busho, that day, what happened in the other matter, the Arif Ahmed matter?
My lord.
While I was about to dictate the judgment, although I was taking it leisurely, my lord. So I was about to dictate the judgment, then I thought, okay, then let me see. When I look into the matter, it has become a cobweb. It's a very interesting facts. Because of this, then I said that I can't pass any order without bringing Iftikhar Azad as a party to
Exactly,
that.
man.
Therefore, I made him a party.
My lord, my lord.
Otherwise, it is difficult. And I think it is a case of directing a review DPC.
Man.
You see, what you have made a mistake out there is you say that he is senior, you give him the civil service.
Man.
No, it is not merely senior. You have to see the other aspect, na? It is seniority come merit. So minimum benchmark has to be looked into.
My lord.
Directly, you can't bring him as a senior. So without a review DPC, it is not. But this will have an impact on the other side. Without hearing him, again the same problem will happen.
My lord. Without him, my lord, the same problem
So
will
we
come.
made him a party.
Yes.
I've asked her to get it served through the racer.
My lord. It has been done.
Yes, what happened here?
My lord, page 70, my lord, kindly see that Lordship earlier directed that us to make a representation.
What happened? Representation?
No, my lord, kindly see the representation was forwarded before the my lord, Registrar General for necessary consideration. Therefore, my lord, matter was lying before the Registrar General for taking course. But prior to that, my lord, all of a sudden, page 84, the same person, MSCTA member, rejected my prayer for regulation. And
Where?
so, page 70, Lordship, is a representation submitted before the my representation will forward before the Registrar General for necessary decision, my lord.
Then who rejected?
No, my lord. Kindly see page 83. If it had been rejected, Registrar General, we could understand by that with certain reasons.
No,
But
no,
page
obviously the forwarding of the representation has different thing from this. This is another representation
No,
filed on
my
24/9.
representation about my regulation part, my lord. Page 70.
Ah.
Representation is the next page 71.
For
That was forward-
regulation. This was forwarded on 12th December.
My lord.
Then what happened?
My lord, thereafter, Lordship, the same person, my lord, page 83. By
Page?
virtue of order dated 16/1/2026, rejected the prayer
Page,
for
page,
regulation.
page?
Page 83, my lord. And it's an office note, my lord. I don't read even it's a decision, my lord.
No.
Annexion 9 of my affidavit.
By virtue of office note, my lord, how they could, my lord. And page 84, my lord, note kindly see, my lord. Whatever
It was
it is,
forwarded for age relaxation.
Yes.
That is done. Then
Then, my lord, page 84, my lord, the same person, member MSCT, Goalpara, page 84 note, my prayer was rejected.
noted that
This
the
is so, my lord,
deep
then why this
concern that
petition
Sri
submitted to
Kolita
the
has
Registrar General?
submitted false age proof before the in 2016. Further, he is above 50 years of age. Hence, his petition for regularization is rejected. You gave a false age proof.
My lord, that is the issue, my lord, 2016, my lord. 2016, while this process was initiated, my lord, it's a fact, my lord, there is no denial. That, my lord, that the person's called, my lord, actually higher secondary, he was submitted, therefore, that point of time, he was rejected. Afterward, my lord, he served as a, my lord, casual employee. Now, the right which has been accrued, my lord, whatever, my lord, but kindly see, once a representation is submitted, and it was forwarded to the registrar for necessary decision, same person, my lord, how it can be rejected by page 84, my lord, and it is not a speaking order, it's a office note, my lord.
My lord, before that, my lord, can I submit one thing, my lord?
Please.
He filed two petition before your lordship. Nowhere he has placed these facts. Now, my lord, in the second petition, kindly come to paragraph 14, my lord. How the facts were suppressed, my lord. Paragraph 14 of the read petition, my lord.
It has been learned that response number 4 and 5 set for a meeting for appointment order for filling up the recent vacant post. The case of Krishna was adversely marked by some waiting.
He said that
Not a separation of, even we have disclosed that what happened in 2016.
What happened in 2016?
But 2016, my lord, while that interview was held, my lord, for regulation, I was found, my lord, that the document which we had submitted not genuine, my lord, and accordingly my prayer was rejected for regulation.
Was? Document was?
My lord, my Actually, I was my lord higher secondary, but I have placed the document for as a my lord,
Class 8 pass, my
class
lord.
8 pass.
Class 8 pass certificate was produced to get the appointment,
it's
my
the
lord.
incident-
And these facts were all along suppressed
No,
in
my lord,
both
there
the
is no suppression,
repetition,
my
my
lord.
lord.
Kindly, I have
No
disclosed-
whisper has been made, my
No,
lord,
my lord, I have
regarding placing of such false document, my lord.
2016 incident. That's why my lord, I was.
Anyways, let's not, yeah. There's a submission, there's a regularization application which was there.
Right.
It was forwarded to the Registrar General. What
Right.
is, what did he do?
Let them take a call, my lord.
That is pending, my lord.
Ask the Registrar General
My
to put the decision.
My lord.
Because that is what I asked on the last.
My lord. Yes, ma'am.
Mr. Samani, I'm very bad in giving order for regularization. And
But we are hoping for best, my lord.
but
No, he's a
see,
vegetable seller, my lord.
Mr. Naik, what has happened now in view of that recent judgment passed in that
Nothing
case?
observed, my lord.
Sukhendu, my lord.
That judgment which has been passed in, what has happened now in respect to those 1991 people and all, the Upendas and all.
Prior to 1/4/1993.
But Upendas has gone for a 6.
And Upendas has been sentenced.
Then what is the effect? And
Effect
thereby directions is been given.
I mean,
Or is the finance department is in turmoil?
yes, no. Lordship, in fact, even after Sukhendu Bhattacharya lordship, Supreme Court passed another,
After that,
not in Sukhendu, in another case, lordship. This is 13 July.
okay.
13 July, therein lordship, court specifically,
Same court.
another court. Volanath case, 2 judges bench. Volanath case specifically mentioned that this Jaggu and Sukhendu Bhattacharya has not laid down any ratio which would be binding in terms of Article 1.
Sumi, do you have it?
It's Nazma Khatun versus State of West Bengal.
Show me that thing, because we are having a lot of difficulties because of this.
It is quite specific, categorical.
It's very difficult. We are now in the problem. One hand, Uma Devi categorically deals. You cannot. Then you have after that, the 3 judges bench in the case of District Bar Association Bandipora.
Official liquidatory is of course there.
Official there, but District Bar Association Bandipora is a 3 judges bench also, wherein also categorically says it cannot be.
Yes.
But if you see the other judgments, you go for all the other judgments, these are all 2 judges. Man,
Yes,
problem lies with us how to take care of this.
lordship. That is what this judgment has stated.
What happened to that other case? You see, in one of these health matters, Mr. B. Gogoi is here? No. There was a health matter pertaining to these, they were all appointed illegally out there, paid for and all. And there were in many districts. I set aside all the appointments were set aside by them, and I dismissed all the petitions. Matter went to the division bench. Division bench allowed 2 petitions on the basis of this and following this Dharam Singh and all.
But in this case, lordship, Jaggu and Sukhendu Bhattacharya has been stated.
You have a copy? No.
One copy I have, lordship.
Just have a look.
And same thing was held by a division bench of Madras High Court also. Sukhendu Bhattacharya has also been mentioned. By division bench of Madras High Court. Not by this. Paragraph 31, C and D.
this gives us some handle. Now, this is, in fact, with due respect, has been all along my position also. You cannot. These are 5 judges.
Yes, Lordship. And 5 judges, one thing your Lordship will notice.
In fact, if you see, remember that order which I passed, there was one person, he challenged, he did not challenge Upendas. In one case, you were appearing in that matter. Some person out there, he after retirement and all, he now asking for regularization and then asking for pensionary benefits. Then I dismissed it. Then I said that he waited all this while others vendors order was passed, and he also got the minimum of the scale of pay. And after taking all these benefits now, you cannot raise all these things. So I say that vendors said this. See what happened.
Umadevi is concerned, Lordship, I always, that is my understanding at least, Lordship. When one hand it is Umadevi, these are there. Umadevi will always prevail, Lordship. Just 3 line Lordship will take note. This is paragraph 14 of Umadevi. It is necessary to put an end to uncertainty and clarify the legal position emerging from the constitutional scheme, leaving the high courts to follow necessarily the law thus laid down in Upenda. That is one position. So far as Umadevi is concerned, for high courts it is binding. Another paragraph is there, Lordship, paragraph 54. Small paragraph again, Lordship. It is also clarified that those decisions which run counter to the principle settled in this decision, or in which direction running counter to what we have held herein, will stand denuded of their status as precedents.
And there is this interesting observation in this judgment, a judgment will also show you. I think this has a, the Supreme Court has made it very clear in this judgment. It is 2017 3 SCC 410. 410. Huh? 2017 3 SCC 410. Huh?
Parties.
State of J&K versus District Bar Association, Bandivara. Now, this judgment is a 3 judges. You see, have a look at this. It is there. And
Yes. What's the
huh?
three conditions? are
अपन ले जाओ, हट जाओ, हट जाओ, हट जाओ, हट जाओ, हट जाओ. Contents of a piece उठाओ, judgment of contents उठाओ. ले आओ. Control down. Right. Control उठाओ. Okay. Yeah, paragraph 10, read it. In the case, in the judgment of the Constitution Bench, the following two issues primarily fell for consideration. The right of employees seeking regularization on the strength of long and continuous work, and the correctness of the directions issued by the courts for regularization of employees under Article 2 to 6. Decision, firstly, with right claimed by the temporary employees to be regularized in services on the basis of long continuance legislative expectation under so and so. The second salient question which the CIA was called upon to answer whether the courts would be justified in issuing directions for regularization based on such features such as equality and long spells of care. On both the counts, the Supreme Court held against the temporary. However, Uma Devi is not an authority for the proposition that executive or the legislature cannot frame a scheme for regulation. So it is the state who can do it.
And that is barred, Lordship. Under 162 state, any scheme pertaining to regularization is not sustainable. That is also a Supreme Court judgment, Lordship.
But here in this judgment it says so. It says so. Then kindly see, but in the garb of regularization, kindly come to this paragraph again. Another paragraph, interesting paragraph is. '29. No, 26. Because official liquidator is a 3 judges. So unless there is on administrative reasons, there was a genuine and legitimate administrative exigencies, if it was not done. Just for example, it is urgently required. Something is required to have it.
Yes, paragraph 15 in Uma Devi Lordship.
In all such cases, it may be left open to the courts to lift the veil to inquire whether the scheme is aimed at achieving the above objective and a genuine attempt at validating irregular appointments. The state NA cannot be permitted to use this window to validate illegal appointments. The second rider which must necessarily be placed is that the principle as formulated above is not meant to create or invest in a temporary or an ad hoc employee the right to seek a writ commanding the state to frame a scheme for regularization. Otherwise, this would simply re-aggregate a claim via. So therefore, there cannot even be a direction by the High Court that you frame a. This is what it is. Now, this is again a 3 judges bench. But sometimes, I, however, don't find this reference of this judgment in most of the cases. Even they refer to the official liquidator. It's a 3 judges, but this is a judgment which makes it absolutely clear what is Uma Devi. Beautifully written out here. Anyways, very difficult. Now you have given me a handle. Good. Anyway, you do one thing, you just find it out.
Yes, ma'am.
Mr. G. Busho, the learned senior counsel, assisted by so-and-so, who represents the state of, for the Gauhati High Court, shall apprise this court as to whether the Registrar General of the Gauhati High Court have taken into consideration the representation submitted by the petitioner and the same, and which was forwarded by a communication dated 12, this is for
no. Forwarded by the communication dated
Page 70, 12 December, madam.
page?
Page 70, annexure 3.
No, that is for age. Page 70, okay. Which was forwarded, the representation dated 24/9/2025, which was forwarded on 12th of December 2025. Full stop. List this matter on 17th of September. In the meantime, the respondents, the Registrar General, Guwahati High Court shall place its decision on the representation so submitted by the petitioner on so and so. Deeply opposed. I'll take, any urgency is there? Anybody? No. Yes, Mr. Das, what is your matter?
Item 13 maybe Item 13 maybe, that may fix me.
Matter pertains to?
There's a hearing, Miller.
Hello?
Termination of service.
Okay, I'll give a date.